This is Sparta!
Hey, boys! Look what I got here!
Hey, where are the white women at?
Hi, what up, perps? You guys let me know if you can hear me okay. I had to switch some stuff around on my setup. Getting a bunch of lag off of one system, trying to do the whole setup deal. It's freaking, it is what it is. So we tried going through these arguments the other day, and of course my internet shit the bed. And I don't know, it shut down and was down for a couple of hours. I couldn't do nothing with it. Crow, what's up, brother? Come out PLA, what is happening, my man? Thank you again for that Magwell. Chris, brother, email me about that slide. Matter of fact, hell, I'll show you the slide real fast. Well, one of them. This is the... Pull that down. This is the 19 slide. So it's Cerakoted, like I said, with the Northern Light Cerakote. It's got the mass comp on it. But email me, and we'll hook it up. I'll send it to you, and let you guys do whatever to help the brother out. It's got suppressor height sights on it. Of course, it's an optic cut. But yeah, I'll send it to you. Either this one or the 17. Just pick whichever one. The Cerakote's not perfect. You got to figure these are parts that I'm working on and learning. But yeah, email me. CNT Designs 2022 at gmail.com is the address that I'll use for all this. But yeah, email me, brother. I'll send that out to you. And you guys can do your thing with it to help him out. Yeah, dude, it ain't no problem, man. It ain't no shit to me. If it'll help him out. DM Foss, what's up, my brother? So we're going to listen to the arguments out of the 7th Circuit. And this is on all the stuff happening in Illinois with the magazine ban, assault weapons ban, the town that's wanting to ban things. So we're going to listen to it. And I want you guys, as we go through it, because this is the 7th Circuit, and this panel of judges is not friendly to the Second Amendment whatsoever. And one of the judges is I've heard from a couple other places like Four Boxes Diner, kind of has a hard on for these things because he's kind of butthurt that he wasn't chosen for a Supreme Court position himself. So he's got kind of a chip on his shoulder from what people are saying, and I can believe it listening to this. So let me see, I've got it there. Let me add that to the stream. Let me get to where the arguments actually start. Relief. Okay, so this was, oh God, 2 weeks ago, I think. Fire Order, what's up, brother? And hopefully my internet will hang out and we can listen to this for a while. And I'm going to try to keep my commentary down to a minimum, although you might see me wanting to absolutely throw stuff. As usual, let's lay down the rules for a Share the Pain stream. Unload everything near you. Don't have anything loaded because you don't want to just, anger and, end up shooting your TV or your computer, because this is going to be frustrating. Krabby Turtle, what is up, my brother? Chamber Defense, my brother. What has happened? How things going, brother? So we're going to listen to this. We're going to do it. And for those of you who, let me move to the side. That's my new Yugo under folder back there. one I got from a guy the other day. It's got the grenade sights on it and everything. Nice gun. That Joker had only had about a 1 mag run through it. Trying to find the date on it, I think it's like a 2012 build because the guy's had it for years. But yeah, it's pretty slick, man. I was going to build an underfolder and came across that. Got that. And so far, I think that's the only AK that I have that is going to stay completely original in its build. There's nothing I'm going to do to that gun. It's going to stay the same way. All right, well, let's listen to some arguments, guys. You guys let me know make sure you can hear these okay.
As the court is now sitting, God save the United States and this honorable court.
Good morning, ladies and gentlemen. We are ready for argument in Bevis against the city of Naperville and some consolidated cases. Ms. Hunker.
Good morning, Your Honors, and may it please the court. I'm Deputy Solicitor General.
Yeah, LaCroix, yeah, it's a militant violent extremist, which is what they were basically calling anybody who disagrees with the government these days. So it's like I've got I don't have them here, they're over in the shop, but I've got some plasma cuts, the #1 MVE of the month and a couple other like that. Yeah.
Sarah Hunger, and today I will be presenting argument on behalf of the state parties, the city parties, and the Naperville parties. Jessica Scheller will be presenting argument on behalf of the Cook County parties. She will be prepared to answer any questions specific to Cook County and otherwise plans to present argument on issues raised in their briefing, such as historical analogs like gunpowder restrictions and other issues related to the scope of the Second Amendment. With respect to my presentation, unless the court has a contrary preference, I will begin with the plain text of the Second Amendment and then turn to the historical tradition, each of which provides an independent basis for this court to affirm the Bevis and Herrera Court's denial of preliminary injunctive relief and reverse the Barnett Court's grant of a preliminary injunction. We know from Bruin that courts must begin by assessing whether the regulated instrument is protected by the plain text of the Second Amendment. We also know from both Bruin and Heller that not all instruments fall within that category. The instruments must be arms, they must be bearable, and they must be in common use for self-defense. The instruments at issue here do not satisfy that standard for at least 2 reasons. First, large capacity magazines are not arms. They are accessories that are not necessary to the operation of any firearm.
And I take it when you say that, you understand some sort of ammunition feeding device needs to be there, but it could be a 10-round device, not a 30-round or something bigger.
Yes, of course, Your Honor. At issue here are only the large capacity magazines that are restricted by the Act. The Act does not restrict anybody's ability to use a magazine to operate their firearm. And because the record here plainly shows, and it's unrebutted by the plaintiffs, that there is no need for a magazine in excess of 10 rounds for rifles or 15 rounds for handguns, that they do not constitute an arm under the Second Amendment. Even, however, if that were not the case, large capacity magazines and assault weapons fall outside of the plain text because they are not in common use for self-defense.
There's much discussion, Ms. Hunger, about a burden. I think the state, the county, the Naperville all place a burden on the petitioners for purposes of establishing this first step. Where is that found? What's the authority for that?
In Bruin, there are several if-then statements that says if the weapon is within the plain text of the Second Amendment, then the government bears the burden of demonstrating that is consistent with historical tradition. If the government bore the burden at both steps of the analysis, then the Supreme Court would not have used that language.
Well, Bruin is clear that the government's got a role here on the second step. It says so. Bruin never says the burden shifts from petitioners to respondents. We're left wanting for the source of authority as to why a burden on the first step would be on the petitioners, aren't we?
Well, I suppose the burden does have to be on somebody, and we know that the government does bear the burden at the second step. And as I said, there is that kind of if-then language. But regardless here, whoever's burden it is, our position is, even if it were the government's burden, that these are not in common use for self-defense. That's because assault weapons make up only 5% of the arms in circulation, and they're owned by only 2% of Americans and 8% of gun owners.
Before we get too far down that path, which we certainly should come back to, because there.
Okay, let me pause this right here. This is an argument. They started using this last year, I think, in one of the hearings in the House Judiciary, where they're saying that even though there are so many millions of ARs and AKs and all that out there, that they're not common use because only a certain percentage of gun owners actually own these. Although more people own these than they know, because people have done like me, like the 308 sitting back there. Hate the way this camera turns. They built their guns. They didn't go buy their guns. So there's no freaking, record of the gun itself. But this is an argument they're using, that they're pushing, that these guns are not in common use, even though there's millions of them out there. They're not in common use because only a small percentage of gun owners own them. This is what pisses me off. There is no common use in the Second Amendment. That shit came about in another case, and I'll have to remember exactly which one later. It may have been the 34, the challenge to the 34 NFA. Either way, this common use bullshit came up, and Heller stated it, and that kind of cemented it into the record, which is also why I say that Heller was a shit case. It was a shit decision. It should have been very easy. It should have been about a one-page decision that said Americans have the right to own arms, period. And that should have been the entire damn decision, not this common use. And then you would get into sporting purposes and all this other horse shit that they come up with. But get ready, because this is an argument they're using, and they're going to start pushing this shit more in Congress.
There's a great debate going on about what we're talking about when we talk about common use. Are we talking about numbers? Are we talking about purpose? Are we talking about percentages? And to what extent, do we anchor this in a particular point in time? But I want to back up and ask you what the state's definition of a bearable arm is. Does that mean something you can carry, or does that mean something that were ordinarily in 1791 in someone's household? Or what's a bearable arm?
Our view is that it likely would mean something that someone could carry, and that is why it is our view that it is not an appropriate standard for the plain text step, and why it makes more sense to look at whether or not something is in common use for self-defense, or else you could literally have shoulder-fired rocket launchers would count as bearable arms, and then you have to go into the second step of the analysis and do this huge historical inquiry when everyone knows those are military-grade weapons that are not protected by the Second Amendment. And so,
well, I take it your opponents concede that even M16s are not the kinds of arms that the Second Amendment protects for personal use for self-defense.
That's correct, and that's a really important point, Your Honor, because assault weapons are virtually identical weapons to M16s, but for one thing, which is that M16s can use automatic fire instead of semi-automatic fire. And sure, that is a distinction, but it is not one that's constitutionally determinative. If you look at what Heller said about M16s, the reason why the state may ban them is because they're weapons of war. It's not because they use automatic fire. And so, yes, plaintiffs have identified that distinction, but they have not explained why it's important.
Okay, I was going to let that play a little bit further, but that part pisses me off too, which a lot of this is going to piss me off. The original challenge to the 1934 NFA was over a short-barreled shotgun. And the judges came up with the decision and said that a short barrel shotgun was basically not useful in military service, so it wasn't covered under the Second Amendment, meaning that if something is useful in military service, then it would be covered under the Second Amendment. This is where the government plays this game of hide and go fuck yourself, and you go first. It's like playing Monopoly with a freaking 3-year-old that just changes the rules of the game whenever they can. It just robs the bank whenever they want, puts hotels wherever they want, just picks up cards and says they're mine. This is playing the game with the government, and it's absolute horseshit.
And we think here, given that we know that the state and the federal government can ban automatic weapons like M16s, and because assault weapons are essentially M16s, we think it could be a relatively simple case on that line alone. But of course, our view is also that we have shown, even though we do not believe it's our burden, that these are not in common use for self-defense, and also that they are consistent with the historical tradition of regulating dangerous and unusual weapons. So again, back to Judge Brennan's question, regardless of who carries the burden here, we believe that the state should prevail. And I would also note that this is at a preliminary injunction stage, where the plaintiffs carry the burden to show that they are likely to succeed on the merits. And here, the plaintiffs have presented virtually no evidence in support of their case. And the state and the city and the county and the city of Naperville have come in with dozens of declarations from historians, from doctors, from medical experts to meet each step of the burden, regardless of where it falls.
Can I ask you another question? Everybody here has been assuming, it seems to me, that in the wake of Bruen, we have this two-part test. First of all, looking at the plain text of the Second Amendment, and if the weapon in question seems to fall within that plain text, then there's a presumption of constitutionality, which then is the state's, I'll just call it the state's burden to rebut. So a two-step test. And I keep bumping into the fact that in Bruen itself, the Supreme Court said, the courts of appeals have been following a two-step test, but we think that's one step too many. And so you know the line.
I do know the line, yes.
And so why are we back in a two-step test anyway?
Well, I have had a similar thought, but I think what the Supreme Court was saying there was that means end scrutiny is the step that's too far. But then, of course, ironically, it did go back and say we're looking at the plain text, and then if that's satisfied, we look to history and tradition. And so maybe it's step 1A, B. I'm not quite sure, but it does seem like there are two parts to the test, even if technically we're out of the two-step test zone.
But just to be clear, you just said a minute ago that it's the state's maybe preferred position, or at least I'm inferring that you mean preferred position, that you can look at the text of the Second Amendment, somehow discern from that word arms, keep and bear arms, the notion that it's talking about non-military weapons, the kind of thing somebody would use for self-defense, perhaps lawful sporting purposes. There are a set of lawful purposes, and that's enough. That we somehow can intuit from those words in the Second Amendment this classification.
Well, I do think if you look at, I believe it's the threshold paragraph in Bruen where Bruen discusses the plain text analysis. The court does discuss arms that are in common use for self-defense. The court could have said bearable arms or something else, but it did not. And so we know that there's something more there than just, is this literally a weapon in some capacity, and can you carry it from one place to another? And so our view is that it makes the most sense to take that language that was used by the court and apply it. And we also think as a practical matter it makes sense, because if you're looking at common use, you're looking at suitability, you're looking at intended purpose, which can also go to whether or not something is military grade or is it used for criminal purposes. And our view is that those concepts are also inherent in this kind of in common use for self-defense line that Bruin used in that threshold paragraph.
I struggle with that argument, though, because in that paragraph, it connects the two petitioners, the people. It never, though, connects arms to in common use for self-defense. That's elided.
Well, it does.
It's because Bruin wasn't about in lawful use self-defense. It was about the right to bear arms and historical restrictions on that right. Fucking douchebags. It was very simple. If the Second Amendment is implicated, then the state has to prove that there are historical analogs to the gun control laws they want to use. It's that simple. I'm a dumbass. I'm a welder. I understand this. But see, these people don't want to understand it. They want these bans. They don't like guns. They don't like people having guns. They have no, it's gonna get me. They have no idea about firearms laws at all. You'll hear them talk about, well, these were banned, and well, you'll hear it in a little bit. It's absolutely frustrating. Gabriel, what's up, my brother? Hopefully you unloaded everything. Just set it to the side. This is I gotta get, I gotta get like a demonstration before I do a share the pain stream, kind of like the stewardess on the plane. This is your buckle, this is your freaking flotation device, because obviously if we're flying over the United States, there's about a 0% chance we're gonna hit water. Hit something hard, I don't want to limp away from it. Unload everything, relax, crack a beer, smoke, roll a joint if you got one, because you're probably going to need it. Let's get back into this. This is horrifying.
Say that handguns, which were the arm at issue in that case, are in common use for self-defense. So I think that's the connection.
Bro.
But you're right. It doesn't say the definition of arm is in common use for self-defense. I think there's a lot in Bruin that we have to kind of look to and interpret. And so from our perspective, that is the language that's used in Bruin, and it does actually make sense as well as a practical matter when courts are looking into what does this plain text inquiry mean.
And we've got to look at this amendment in light of all the amendments. And I can't think of another constitutional amendment that would be approached in this manner that would read it so narrowly from the front end. We certainly don't read the First Amendment that way. We don't read the Fourth Amendment that way.
Well, I don't necessarily think that that's a narrow category. In common use for self-defense, for example, the court has already said means handguns. It can also mean any number of other weapons, for example, the semi-automatic weapons that are not restricted by the act and that are in common use for self-defense in some ways. There are a lot of weapons out there, and we're talking.
Pause that for a minute. Hey, Brooke, what's going on? Yeah, pain and suffering, Brooke. Yep. If you don't know the rules, just unload everything near you that's within reach. I'm living dangerously since I'm still got my carry gun on, but yeah, it ain't hard, Brooke. Not for normal people to understand. And see, here's another key you got to look at when they're talking about this stuff. When they say, in use for self-defense, they want to say that the only self-defense that they want to talk about is when someone actually fires the gun in self-defense. And they still won't acknowledge the times where people use ARs and AKs and stuff to do that.
About a very narrow group of weapons here. And so our view is that it's not unnecessarily or unduly narrow. And I would also note that even though the Second Amendment test is different in some ways than First Amendment or Fourth Amendment or Fifth Amendment, it's certainly not unheard of for the threshold question in some of those tests to be more significant, especially in any given particular case. That would involve either a robust legal or factual analysis. For example,
Hell yeah, Brooke. Are you going to lie, or is there going to be any video your testimony? If it is, send me a link and we'll play that shit live. Yeah, Brooke, 100%. Yeah, the Second Amendment has nothing to do with self-defense.
I know right now, there is a big debate over cell phone encryption under the Fifth Amendment. Is that a statement? That's the threshold question, and that could be the one that the court is looking at more robustly in any specific type of case. If you're looking at dog sniffing cases under the Fourth Amendment, whether or not something is a search is a threshold question. And so while it might not be as robust of an inquiry or a slightly different inquiry, we don't think it's different in kind, such that there cannot be some teeth to the plain text step.
Can I ask, when you talk about arms in common use for self-defense, do you see this as an objective test? Do you see it as a subjective test? When somebody buys their AR-15, they say, well, I personally expect that I'll use this for self-defense. Is that enough to make it self-defense, or do we need to look at statistics, or what? How do we make sense of it?
And see, that's the judge asking, well, do they expect to use it in self-defense? I don't expect to use any of my guns in self-defense. I have them in case I have to use them for self-defense. Just like I don't expect my house to catch on fire, but I have fire extinguishers. I don't expect it to happen. I have it in case. I don't have seat belts in my car because I plan on wrecking the shit and using my seat belts. Although I hate being forced to wear a seatbelt. There are seatbelts in my car just in case. Yeah, and that's the thing that they hate them, and like the 308 bill back there, they ooh boy, they hate those spooky old ghost guns.
I don't think it's a person by person, subjective test, but I do think what people generally.
Yeah, Brooke, maybe I should send out barf bags for it. Barf bags, Motrin for the headache, maybe something for the sickness, the nausea,
Use for self-defense is relevant, and we have several expert declarations. I believe.
Yeah, Brooke,
the Andrew
100%.
Declaration, Bussey, and Yergolaitis that say that Americans typically choose other weapons for self-defense. They typically choose handguns and shotguns, and that's because they are more suitable for self-defense.
Sure as shit,
purposes.
Kurt.
You can conceal them, you can maneuver them more quickly, and they are not overpowered in the way that assault weapons and large capacity magazines are for self-defense purposes. And so I imagine, it might be slightly different for each case, but
I got to put this out of reach.
Look at statistics, intended
Let me
use,
set this
expert
over here.
declaration. Also here, just the history and nature and marketing of these weapons shows that they're offensive, militaristic weapons. That's what they were designed for, and that's how they're being used today. That's why they're being regulated by the state and these localities, because they are the perfect instrument for lone shooters who with little to no training to take, an assault weapon and large capacity magazines and murder people in minutes.
So wouldn't that argument work for someone who has little to no training that would use one in self-defense? Which, people can train on their own. They don't have to go everywhere to get training. There's plenty of stuff out there where you can watch and you can train on your own. Hell, I did it a lot before I went to Warrior Poet. Warrior Poet was a whole nother level, though. It was freaking great training. But these people are absolutely insane. And it's always, again, you got to put it through the lens of it's always the game that the government wins and we lose. That's always their game, no matter what. No matter how they have to twist facts, no matter how they have to twist wording, change meanings of words, all that stuff. It's always the game of the government wins and we lose. Yeah. Brooke, you've seen this stuff. You've testified before. And I will say this, Brooke, you are a saint, because there's no way I could deal. Well, I probably could. I'd have to take a whole lot of Xanax. But there's no way I could stay calm in front of some of these people testifying. I don't think they'd really like to be asked, "Are you an idiot?" In the middle of a questioning session.
Not seconds. And that wreaks havoc not only on those who are present through injury and death, but also the entire communities. They're very traumatic events with economic consequences. It's also a very significant burden on law enforcement. And so what is happening is these mass shooters are using them in offensive ways because that is what they were designed for, although of course they were designed for the battlefield. But
We spent quite a bit of time on the first step. Let's move to the second step. We're supposed to ask the how and the why,
yes.
how the regulation burdens and why it burdens. Is there any why in support of the act that did not also apply to public carry in Bruin?
To public carry in Bruin. Yes, Your Honor. I think this is a very specific why here, which is what I just discussed. We have these lone shooters that are taking these offensive militaristic weapons, these specific weapons, and they are using them to, attack communities and public events. And I think that's different than the concealed carry why, which is more kind of interpersonal violence on a kind of a one-to-one level. And so,
Well, it's all gun violence. You're segmenting a portion of the gun violence
That's
and
right.
saying that's the why.
it is. And, I don't think it would be sufficient for us just to say public safety, generally, and that's not what we're saying. We have a very specific reason for having enacted these restrictions, and that why does line up to the why of the early 20th century with the restrictions on automatic and semi-automatic weapons, which I would note even plaintiffs do not dispute that history is relevant here. And those are virtually indistinguishable from the restrictions here today. And we know from Heller and from Miller that those types of restrictions are permissible. I would also...
But can I just interrupt and say, one of the big themes that your opponents urge in all of their briefing, and believe me, there are plenty of briefs filed in this case, is the fact that horrible as it is, that there are these mass
A cool
shooting
deal, Brooke.
incidents. There are not that many of them compared to the number of people who own these weapons. And they say, why would you take away the guns from all of these other people who aren't going out there and shooting out of a hotel room just because some rogues are?
So I have a few responses to that, Your Honor. First, the number of mass shootings, as our experts have explained, is unfortunately increasing. So there are, a substantial number of these mass shootings in this country. I would also note that
I must say, though, I don't understand
Don't
how
wonder I
anything
smoke
but
so
an
much.
effort to get means and scrutiny in through the back door. You're saying that
And see, this judge understands where she's going with it, with the means and scrutiny. General Sorrow, what's happening, brother? Which is what they've used forever, which is basically putting the state interest over, your individual right. But again, this judge right here, I believe, is the one who kind of has a chip on his shoulder. And this case is, when they write their opinion in this case, because this argument was like 2 weeks ago, I think, or a week and a half ago. And I was working, couldn't stream it then, but it's the anti-gun side is going to win in this case. And then it should step up to the next level and then maybe make its way to the Supreme Court before it gets shut down. And hopefully the Supreme Court will shut it down. Hopefully. But in the meanwhile, the thing that sucks, in the meanwhile, while this is going through the courts, there's no injunction on it. So this is completely enforceable in the state of Illinois right now. You are going to have people that are going to get locked up over this, that are going to get charged with these violations, you name it. And they're going to basically be stuck until this goes to the courts. And then if it goes to the courts and the Supreme Court finally shoots it down, those people have no remedy to get whatever they lost back. That's another thing that drives me insane about this. And yeah, Brooke, you're right. It all costs money.
The state has a good reason for doing what it's doing. That's exactly what the means ends business is about.
So
How can we, given what Bruin said about means ends arguments, how can we consider this?
I think we can under the justifications prong of what is relevantly similar. The court specifically asked to look at the how and the why, which it noted included the justifications for the act. I understand that the court did also say that there cannot be any means end scrutiny, and so we are not asking the court to engage in any type of interest balancing or means end scrutiny. We are presenting the justification for this act, and we are saying that it is relevantly similar.
I hope you see you're just repeating the reason why I asked my question. You're asking us to consider through the back door something that Bruin bars at the front door. And I wonder whether that's consistent with our role as what the Constitution calls an inferior court.
Well, it is consistent with Bruin because there's
This dude mentioned an inferior court because the Supreme Court in their decision was talking about inferior courts. And he's a little butthurt over that whole thing.
another door in Bruin, which is the justifications. And I understand that that might be slightly contradictory for what the court would have said in Bruin, but it is what the court said. They did use the word justifications. And
So we not only get the two-part test that they expressly said was one part too many, but we also have the very same criteria that courts of appeals used before Bruin, even though they were expressly disapproved. Does your argument really hinge on this?
it does not really hinge on this, but I would also note that the justifications, in the way that we see it, fits into the historical tradition approach. But no, our argument does not hinge on this because these are not weapons in common use for self-defense. They are dangerous and unusual, and they are consistent with the historical tradition whereby states, the federal government, and other localities will regulate a weapon once it has been introduced into society, once it proliferates to the point where it is causing harm, and then the state comes in to regulate in that respect. And so
So I take it you're saying there's no statute of limitations on the state. A weapon can be introduced, and maybe the state doesn't realize right away that it's going to be a problem, and at some later time, the legislatures and the appropriate authorities in the state say, actually, it is turning out to be a problem. So there's no what has been called by some an easement.
well, no, Your Honor, and that, in our view, that is the way that governance should work, is that the state is only regulating when there is a problem. Otherwise, there would be over-regulation by the state, and the state would feel the need, as soon as any new weapon came on the market, to regulate it immediately, or else it would lose the ability to do so. And I think that does not benefit anybody. It does not benefit the state or our residents, or those who would like to use those weapons. I do see that I am going into my rebuttal time.
Can I ask you one last question, though? You've a couple of times referred to dangerous / unusual, and there's been some side debate about whether something has to be both dangerous and unusual, whether it needs to be dangerous or unusual, unusually dangerous. I mean, you can play.
Where do we end up with this? And I'll have to track it down. This dangerous and unusual crap, talking about arms. And they're arguing that a lot of these guns, AR, shit like this, are dangerous and unusual. Again, they argue the unusual part because only a certain amount of gun owners actually own them, and the dangerous part, of course, because these mass shooters use them. That could be used to ban any innovation in the firearms industry. Think about it. If caseless ammunition came back around, if they figured out a polymer that was good enough for the gunpowder, so you ended up with another caseless gun, kind of like the German Kraut Space Magic, and believe it or not, there were some caseless 22s back in the day. So if they can argue that something is, it's dangerous and unusual, no one owns it, that kills all firearms innovation. Nothing new could come out because it would be new and it would be unusual and dangerous. These people are insane.
With these words as you wish,
Yeah, 100%.
It could make a difference, you know, because if it's dangerous in a way that is not typically the case for other guns of various kinds, other firearms, then maybe that's one thing. If usual just means how many of them can you count, then there are a lot of them out there. Everybody keeps using this number 24.4 million. So what are we to make of that little phrase?
So we view that term more as a term
Thing's
of
got a
art,
hole in
and
it
not
somewhere.
looking at is something unusual, aka, is it common? And that is consistent in our view with the history, because there were weapons that were popular, like the automatic weapons or certain knives and clubs and pistols in the 19th century, but that were restricted, especially in the 19th century with respect to concealed carry and then possession requirements in the early 20th century. And the Supreme Court has noted that those are permissible. And they could not have done so if it were the case that any type of popular weapon could not be dangerous and unusual.
Thank you.
Thank you.
Now, remember, this is a couple of cases that have been consolidated, so it's not the normal oral argument where you hear one person from the state and then one person from the plaintiffs. You're going to hear a couple people from the state and a couple people from the plaintiffs.
Ms. Scheller.
Slippery, he said. Little Major Payne reference.
Good morning, and may it please the court. My name is Assistant State's Attorney Jessica Scheller, and I will be presenting argument this morning on behalf of the county defendants. There are three independent bases upon which the court may affirm the denial of Dr. Herrera's preliminary injunction beyond those discussed by the state in their presentation this
Now, this Dr. Herrera, there's a couple of different cases going on here, remember. One is a state case. Another one is a county case where a county in Illinois said you can't have high-capacity magazines, you can't have assault weapons, and this doctor is one of the ones who is a plaintiff in this case. He basically had to take all of his stuff and bring it to someone outside of his county to hang on to while this shit's going on. BV, what is up? What's happening, brother?
morning. We would like to draw your attention to these points. The AR-15 sought by Dr. Herrera is not protected by the Second Amendment. It is not an arm, as that term was interpreted by Heller. Next, the AR-15 is not protected as its use is not consistent with this nation's historical tradition of moderate self-defense. It is instead a dangerous and unusual weapon. And finally, this nation's historical tradition supports regulation of materials causing mass death, even those protected by the Second Amendment, such as gunpowder.
Isn't the why for gunpowder, though, different than the why here? I'm on the second step of Bruin.
Yes, of course.
The why for gunpowder was to prevent fires and explosions. That's why they limited it, right? Isn't the why here different, whether it's public violence generally or a segment of public violence?
We would disagree, Your Honor. The why in this particular instance is to prevent mass death caused by the carelessness or callousness of an individual or small group of.
Eagle Run, what is up? Eagle, this is the oral arguments out of Illinois for the Illinois assault weapons ban and the, as a county, I can't remember which one, their assault weapons and high capacity magazine ban. These arguments happened about a week and a half ago. These are the ones we're completely expecting to lose in the Seventh Circuit, and then it's going to move up from there. Brother, frag out. What is happening? Damn, we got some cool ass people in here.
Factors. That is the same why, which led to the regulation of gunpowder under the English common law.
Now, I got to get to this gunpowder regulation real fast. It's like the 1783 Mass Act, and it was a regulation on gunpowder. And what they did was they went around and looked for anybody who had gunpowder stored in an unsafe way. They mention in that law that the private citizens owned cannons, mortars, grenades, muskets, swivel cannons, every implement of war private citizens owned. If they found someone storing gunpowder or one of these cannons or grenades or mortars, if they found them storing them improperly, they brought them to the court. They went through a trial with a jury. And if they confiscated those items, they sold them right back to the public. So it wasn't a prohibition on citizens owning arms. It was a fire regulation because in these towns, houses are close together. And if gunpowder catches on fire, you're going to catch more shit on fire. It wasn't a prohibition on people owning arms.
And carrying through our nation's formation.
You see how we might have some concern with that being overbroad.
Yes, however, there is an additional why which supports this contention, and that is, as noted by Heller, gunpowder restrictions were in part to protect the firefighters who were coming onto the scene to help aid and render assistance. And similarly here, we have provided several instances where law enforcement officers responding to mass shooters armed with AR-15s are afraid to engage the situation or otherwise delayed in engaging the situation while they pull in military equipment such as a Bearcat or a personnel carrier to breach the wall, or in the unfortunate circumstance of Uvalde, where law enforcement did not engage at all.
Uvalde, where they could have literally walked around to the window of the classroom and shot the son of a bitch. Instead, they sat around, well, some of them. There were a couple of guys that really tried to get in there. But for the most part, they sat around while children got killed. They literally could have walked to the outside of that building, looked through the window, and shot the fucking dude. Hundreds of officers on scene. They wait around while children get killed. This isn't about AR-15s. That dude could have been in there with a damn 22 and had enough time to do what he did. Because he's a piece of shit. And if, no kidding, and people have heard me talk about it before, I teach in a college. I would rather be armed and have some way to defend my students than just stand there trying to lock a door getting shot. I'll shut up for a second.
Due to fear of engaging with that particular weapon.
So isn't Mr. Herrera's argument precisely that? He needs to be protected when, as a SWAT medic, he goes to the scene?
Dr. Herrera is not a member of the SWAT team. He is a medic. However, if that was necessary as part of his participation in the SWAT team, it would certainly be outside of the prohibitions of our ordinance.
Now, this doctor, just to throw some more information out here, this doctor works with the SWAT team as a medic. He basically is in the background, and he only gets called up once a situation's been handled and if he has to treat people. He's not running and gunning with the SWAT team. And these judges get this argument completely wrong when they start asking their dumbass questions.
And I suspect the other regulations as well. The Cook County Ordinance does provide an exemption for law enforcement officers.
So for Mr. Herrera's particular case, Dr. Herrera's particular case, you're indicating he could carry a weapon to the scene. Is that your position?
No, I do not believe that Dr. Herrera is a law enforcement officer, nor do I believe he has put forth any evidence from any entity that he is required to carry this weapon as part of his duties related to his
He's not
volunteer
required
capacity
to.
in the SWAT team or paid capacity, whatever the case may be.
So you're just saying that if the SWAT team wanted him to have a weapon, he would fall within the exemption, but he's just in the truck, basically.
Correct. But turning back to our first argument, which I think is incredibly important for this court to consider, Heller and Bruin instruct us first to look at the plain text of the Second Amendment, and so rather than calling it a two-step test, I will say the plaintiff is required to plead a prima facie case, bringing the prescribed conduct within the scope of constitutional claims. And he's failed to do so here. The threshold analysis on the merits must be whether the AR-15 sought by Dr. Herrera falls within the plain text of the Second Amendment.
BV, dude, I don't get it. I don't get why. I can conceal and carry every day. I'm out at Walmart, go to the gas station, you name it. I'm carrying. I don't get why there's such a hang up about teachers such as myself carrying in a classroom. I'm carrying concealed. I'm not laying my gun out on my desk and like, hey, that's there in case I need it. No, it's on body carry. And that is going to be a hell of a lot better than having a damn stapler in my hand if someone ever decided to start shooting up the school. The building where I work in is a lot like a lot of other schools where it's glass windows up front. Even if I lock the front door, it doesn't take nothing to get in that building. Even a lot of very liberal teachers would rather carry or have something on them to defend their students. And they're not going out there playing Rambo. You don't have to do that. You pull your people back to an area that you can defend. And if anything comes through there that's not wearing a badge, it gets shot. It's simple.
And put simply, it does not. As to the plain text analysis, Bruin is of limited utility, as the parties stipulated the Second Amendment applied to handgun regulations. However, Heller is both instructive and dispositive on the issues raised here. In Heller, the Supreme Court interpreted the operative clause of the Second Amendment, and before turning to the verbs keep and bear, the court interpreted their object, or arms, at page 581. And applying a historical understanding, the court noted that arms in 1773 was understood to mean weapons of offense or armor of defense. However, the court went on and stated the term was applied then as now, meaning in 2008, to weapons that were not specifically designed for military use and were not applied in a military capacity. That's Heller at 582, and it's particularly deadly to Dr. Herrera's claim here when you look at the AR-15, how it was developed, why it was developed, and at whose request it was developed. In 1957, the U.S. government invited Armalite, a weapons manufacturer, to produce a lightweight, high-velocity rifle with firepower capable of penetrating a steel helmet or standard body armor at 500 yards.
So you have actually spelled a lot of this out in your briefs, and so in the interest of time, I guess I'm having trouble, and my trouble extends to what your opponents are going to argue too. As I stare at the language of the Second Amendment, there's a lot of interpretation that's necessary. I guess I'll just say that before you can understand, what's the point of the prefatory clause. Heller said it doesn't drive the whole thing. Fine, there's an individual right, but what are the arms? What does it mean to keep and bear the arms? Who are the people? I mean, all of these are terms that require some interpretation. And in our case, unlike Heller, unlike Bruin, requires us.
Yeah, Eagle, it's a situation that has to be handled basically teacher by teacher. And some teachers aren't going to want to carry. That's okay. You're not going to be forced to. But a teacher that does want to carry, say someone who's got, their shit together and they carry every day anyway, let them carry. And I will guarantee you there are more teachers already carrying on campuses and in schools than people would like to know, whether they have their gun in their briefcase or something like that, or in their bag. I will guarantee you there are a lot of teachers that have something near them and would be ready to go. Yeah, you're right, Eagle. It is a bit of a head in the sand situation. But like I said, man, let the teachers who want to carry, who are already carrying in the rest of their life, the teachers who don't want to carry, that's fine. Don't carry. I would really like to see a system, and I've played with this idea a few times since like we've got this big open campus. I would like to see some sort of visual alert system on campus so that if something ever did go down, that if a student is pulling into the parking lot, there is a pole there, whatever, lights going, saying, hey, don't get out of your car, get on down the road because there's something happening on campus or campus is locked down. And we've been locked down before. At my previous school and at the college I work now, we've been locked down before because there was stupid stuff going on and then we're locked down. But in an open campus like what we've got, even with the text alert systems, you still have people coming on and off campus because they're not checking their phones or they don't get the message till they pull in the parking lot. I would like to see, okay, so for an instance, we have tornado sirens and stuff all around our area, which is an audible alert that, hey, if there's something happening, you hear these towers go all plant, 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 get to someplace low, whatever, warning you about this possible tornado. I would like to see something like that on a lot of campuses that would warn if there was a possible mass shooter on campus. That way people pulling onto campus would be warned, and then they know to get their little happy ass on down the road instead of getting out of their car and walking around the parking lot like a freaking, meat target. Yeah, Eagle, that's something that these days has to be addressed. And it's 100%, man. You're doing the perfect thing and addressing it with her. The issue in a lot of places is if you have a shooter who actually wants to do damage, they're going to do damage. Handguns, rifles, doesn't matter. They are going to do damage. Yeah, VB, there's a lot of times I do ignore stuff like that. But it would be another way to warn students coming on and off of campus at a time like that to, that there was a threat and they needed to get out of there. All right, Brooke, take it easy.
To zero in on what are the arms, and I'm curious as to what you think the Supreme Court is telling us we need to do, whether we should just all become, weaponry experts and apply our own understanding, or whether there's some historical test, and that's a little hard to do since, as you were just saying, it's not until the 1950s that these particular weapons are fully elaborated. Then there are other people who say, they were repeating things back in the 15th century, but I think it's fair to say these are distinctive weapons. But how do we do this?
I think there are two different questions that the court could ask itself in this particular circumstance. And the first is, it would look to Heller, which said that Miller stands for the principle that it is the characteristics of the weapon which determine whether or not it is protected. So now we're looking at weapon.
Again, she's citing Miller, and Miller said if it wasn't useful in military service, it wasn't covered by the Second Amendment. Meaning, if it was useful in military service, then it should be covered by the Second Amendment. And they're calling these weapons of war, which are useful in military service, so they should be covered. And they're arguing the exact opposite of that. It's that whole game. Hate to break it to anybody, but if you followed me for a little while, I'm a little rough around the edges. But it's that game of hide and go fuck yourself. We win. Oop, hold on. I lost it.
On this, because these are not weapons in common use for self-defense. They are dangerous and unusual, and they are
Claim why, which led to the regulation of gunpowder under the English
Let me get
Common
back to
Law
where
and
we were
carrying
at.
the AR-15, how it was developed, why it was developed, and at whose request it was developed. In 1957, the U.S. government invited Armalite, a weapons manufacturer, to produce a lightweight, high-velocity rifle with firepower.
That's not exactly the true story of it. Armalite already had a basic AR-15 design, shooting a 223 round, selling it to the public, and there was a general who had a hard-on for this intermediate cartridge and decided he wanted to get with Armalite and get them to produce a military rifle. That's pretty much the way that went.
Capable of penetrating a steel helmet or standard body armor at 500 yards.
That is absolutely wrong.
So you have actually spelled a lot of this out in your briefs, and so in the interest of time, I guess I'm having trouble, and my trouble extends to what your opponents are going to argue too. As I stare at the language of the Second Amendment, there's a lot of interpretation that's necessary. I guess I'll just say that.
No, there's not.
Before you can understand.
It's simple. It's very simple. Necessary to a free state. Militia, right of the people, and it is the right of the people to keep and bear arms. And the founders at the time wrote many letters in support of it, explaining their position. There is no interpretation necessary. You person, I'll say that, person. I'm gonna try to behave.
And, what's the point of the prefatory clause? Heller said it doesn't drive the whole thing. Fine, there's an individual right. But what are the arms? What does it mean to keep and bear the arms? Who are the people? I mean, all of these are terms that require some interpretation. And in our case, unlike Heller, unlike Bruen, requires us to zero in on what are the arms. And I'm curious as to what you think the Supreme Court is telling us we need to do, whether we should just all become, weaponry experts and apply our own understanding, or whether there's some historical test, and that's a little hard to do since, as you were just saying, it's not until the 1950s that these particular weapons are fully elaborated. Then there are other people who say, they were repeating things back in the 15th century. But I think it's fair to say these are distinctive weapons. But how do we do this?
I think there are two different questions that the court could ask itself
Free
in this
my
particular
freaking hair.
circumstance. And the first is, it would look to Heller, which said that Miller stands for the principle that it is the characteristics of the weapon which determine whether or not it is protected. So now we're looking at weapons.
So we're all, just to pause, we are all still on the same page that when we see that word arms in the Second
Kingpin,
Amendment,
what's up, brother?
we actually know that we have a sorting job. Maybe nuclear weapons are on one side of the sort, and small handguns that many people keep for their protection are on the other side. And then there's just these myriad of other things. And so,
Okay. Nuclear weapons are not commonly owned, and they actually are dangerous and unusual if you want to use that argument. A rifle, whether it's full auto, 5.56, 223, 45 ACP, you name it, those are all common. And the only reason that machine guns aren't more common is it's a closed market. After 86, they said no more could be manufactured. MC, what's up, brother man? Tactical Fud checking in. What's up, Fud?
it's the sorting principle that I'm interested in.
So I think the next step, or the sorting principle, would go to the historical legal traditions announced by Blackstone and carried forth through our nation's tradition of moderation in terms of self-defense. So Bruin, Heller, McDonald, all of these cases and all of these precedents stand for the notion that the core right is self-defense. And if we look to the founding scholars, there was always layered within the concept of self-defense a principle of moderation.
No. No, because the Second Amendment wasn't about self-defense. The Second Amendment was about the people being armed so that the government didn't have a monopoly on force. Self-defense was a given. That was always a given. People have the right to self-defense. The founders spelled that out in many, many letters. People of that time, scholars of that time, like I always mess his name up, Tench something. He spelled it out and said that all arms, weapons of war, were the birthright of Americans. There wasn't any question on whether we could own a tank or a missile launcher or anything like that. People owned cannons and mortars and explosive shells and grenades at that time. They owned every weapon that the government owned, and in a lot of cases owned way more weapons than the government owned, because the government had to go to the people and say, hey, you got this ship full of cannons and all that. We kind of would like the supply stopped from this other country. So we're going to give you a letter of marque, and you can go out and shoot these ships up and then claim whatever you want. Hey, town, you have these cannons. We would like to employ those in our fight. So we're going to, supply you with, gunpowder and cannonballs and shit. And you just launch them in the direction we tell you to launch them. Mortars had explosive shells. They were privately owned. The way they twist up history is amazing to me. Goonbeam, what is up, brother? Man. Next time I get paid, brother, I got to hit you up.
That goes back to cases resolved by the King's Bench, cases resolved at the time of the founding, and it carries forward through Illinois law to this day. There has always been a notion that you cannot use an excessive amount of force, even in self-defense, or it becomes a crime in and of itself. And so while...
So she's basically saying that if someone attacks you and you use an AR-15, then you're using excessive force. Yep. Everything's not within reach and it's unloaded.
Illinois law certainly doesn't govern the constitutional interpretation. It does inform this court of the nation's historical tradition with regard to regulation and how self-defense
BV 100%
applied. And self-defense is not an unlimited right. It's not designed for someone to play commando with military-grade weaponry, but rather it's meant to defend against confrontation of some limited means, as acknowledged in Heller, which said that, it's not designed to prevent any type of confrontation, but there is some type of right to defend oneself. And we think Blackstone is the touchstone to determine where the founders were and what their thinking was when the Second Amendment was enshrined.
Ms. Schiller, what is your best argument for historical analog? Is it gunpowder? What are you relying on if you're putting forth your best foot on that stuff?
Yes.
We have two.
That's all I got to say.
If
yes.
we're dealing specifically with regulations within the home, both gunpowder and spring guns are historical analogs. We believe gunpowder is an appropriate.
Okay. Spring guns, in different, well, there's a couple that she mentions. One is basically a trap with a tripwire where you'd have a gun pointed at your door, and if someone came into your home, they'd get blasted because there wasn't a lock on the door. Yeah, there wasn't a physical lock on the door. So your buddy comes over late at night, trips, fucking bam, he's gone. So they were very indiscriminate. That's why those were banned. The other one she goes into is a trap that for animals, which was basically, again, some sort of firearm set up with a tripwire pointed at like an animal trail, and if an animal walked by, pow, they get banged. Eagle, take it easy, brother. So those got banned.
Appropriate analog because it's the Y is a nice fit with regard to preventing mass death. But the spring gun is also a historical analog because that was certainly a firearm kept within the home to protect the home. And yet it was determined to be unlawful because of the indiscriminate way in which it would effectuate its remedy.
Because
right?
it was protecting property, not personhood.
Not necessarily. It was to protect against intruders. And it would be an unusual analysis if it was okay to ban something that could unintentionally harm third parties, but not to ban a similar problem where it's used with intent.
Yeah, I have
There's
seen that,
simply
BB.
no analog in the law for that type of logic split. And unless the court has any further questions, I see that I am close to my rebuttal time. Thank you.
Thank you, counsel.
That's a hell of a damn mousetrap. It's like a 32, I think, in one of them. Yeah, that's a hell of a damn mousetrap. Eat the rat. Swear to Christ.
Ms. Murphy.
Do not have enough drugs.
Good morning, Your Honors, and may it please the Court. Erin Murphy, counsel for the Barnett plaintiffs. This morning, I'm going to be prepared to address the core issues that are common across all of the appeals. Mr. Mag will then present arguments on behalf
fire,
of the
100%.
plaintiffs
Yep.
who are parties to the Barnett appeal, and Mr. Dickey.
Further
will
you go up
present
that scale,
argument on
the
behalf
further
of
you
Herrera
fuck
plaintiffs and
around, the
address
more
the
you
issues
find
that are
out.
specific to the Herrera case and the city and county ordinance that are at issue there. Millions of law-abiding Americans possess the semi-automatic rifles, pistols, and shotguns that Illinois has newly banned, and millions more own the magazines that Illinois has now declared illegal. Under the Supreme Court's decision in Bruin, that forecloses the state's effort to prohibit them, as Bruin teaches that our historical tradition is one of protecting arms that are in common use today.
Buckle up your
The
seatbelts,
state's
kids, because
evolution-
these judges
Your
get worse.
whole argument seems to depend on the word today, in common use today. So I'd like you to consider the ban on machine guns in 1938. Was that
34.
unconstitutional? Because in 1938, machine guns were in common use.
Listen to this judge, because he does not understand the law. It was the 1934 NFA, and it was not a ban on machine guns. It was a tax, which at the time was effectively a ban because the cost was of the tax was just as much as the gun itself, which is funny because there were no background checks. So the only people that could really afford those at the time were the criminals that they said they were trying to stop. Think about it. In 34, Al Capone could go get a machine gun. He had plenty of money to pay for the tax. There was no background check that said, oh, you're Al Capone. You're a felon. You can't have that gun. There was no check like that. So the only people that's really stopped or priced out of the market to own these guns were your poorer people, your everyday middle class people. That's the only people that stopped.
Much as the AR-15 is in common use now.
I don't think so for two reasons. First, they actually were not nearly anywhere near as common as the AR-15s today. As the state's own expert has said,
There are a lot more weapons altogether now than then.
Certainly, but as the state's own expert said, they were not particularly common at the time. But more importantly,
They were especially common in Chicago.
what
Listen to what he's focused on. Chicago, all the crime, the mobsters and stuff in Chicago.
Heller said is that the reason they could be prohibited is because they were not typically possessed by law-abiding citizens for lawful purposes. Those are the precise words that Heller used in the specific context of explaining why Miller was consistent with the historical tradition of prohibitions on dangerous and unusual weapons. The court said what was different about
Miller was complete horseshit. And the only reason the court in the Miller case actually decided that case for the government was because the president at the time was threatening to pack that court, and they were under a ton of damn pressure to come up with the bullshit decision they came up with.
About machine guns was they were not typically possessed by law-abiding citizens for lawful purposes. And that is quite different from what we are talking about here today.
And do
because
we have data? But on what basis was that statement made?
the Supreme Court's statement,
Yes.
Yeah, BV.
I'm assuming it was made on the record that existed before, that they looked at themselves in terms of the historical record. But at this point, what we know is that at the time that machine guns started to be banned back then, there were only a few thousand of them that had been sold at all,
Again, they
which
weren't
makes
banned.
them exceedingly less common than anything we are talking about today. And they
Now, this is a lawyer for the plaintiffs in this case. And this judge is trying to force her to argue the 1934 NFA instead of just arguing on the guns that we're talking about now, AR-15s, AKs, shit like that. But I also don't understand in some cases, well, two trains of thought. My train of thought is that she should be arguing that, yes, the 1934, where it is not at issue now, the 1934 NFA is unconstitutional, period. Although we're arguing about different guns right now, if a case comes up again, about the 1934 NFA and machine guns, we can argue that case then. The other train of thought is she just should have just said from the start, we're not arguing the 1934 NFA right now. We are arguing about these AR-15s, AKs, all that are commonly owned right now. This is what we're arguing about. We need to stay on task here. If a case comes up with a 1934 NFA, then we will argue that case then. That's not the case we're arguing now. With me, probably a good thing I'm not a lawyer arguing for this stuff, because I would have busted their chops on so many things already. It's not even funny. But I would have flat out said that the 1934 NFA is absolutely unconstitutional, period. And it wasn't a ban. It was a tax, a prohibitive tax, but it was a tax. It was not a ban. The manufacturer, matter of fact, when they were arguing about talking about the 34 NFA in the congressional hearings, they admitted flat out that they could not ban machine guns, and that ban on machine guns would be unconstitutional. They couldn't ban the manufacturer. They couldn't ban the sale. They said that in the hearings. That is part of the congressional record. That is a historical document. Why the fuck these people can't find that shit and argue it, I have no idea.
And I would point you to the record in this very case. The state's expert says they did not find a home with law-abiding civilians. They instead principally found a home with gangsters and mobsters who were using them for criminal purposes. So it seems to be common ground here today at this point that the reason that those were the type of arms that could, at least
Counsel,
one of the
I
reasons.
hope you can see why it troubles me.
Kingpin, that's
Because
where
if
some
we
of this
have
is
a
going.
historical inquiry under Bruin, why could it matter? Why should it matter what was in common use in the 19th?
There are bills in Congress. At least they were submitted last Congress. I got to check this Congress. But there are bills that have been submitted to treat all semi-automatics just like machine guns and put them under the NFA. And then they want to raise the tax.
1930s. Who owned guns in the 1930s? Or for that matter, who owns guns in the 2020s? It's not historical. It's a matter of current events. And normally we think that current events are for legislatures. History is the domain of the Constitution.
So as I understand, what Bruin is teaching is that we take historical principles and apply them to modern day facts. We take the historical principle that weapons that are in common use today are the types of arms protected by the Second Amendment. The answer, applying
Where does that come from as a historical principle? That the Second Amendment protects whatever weapons are in common use whenever we...
Okay, there was no common use written into the Second Amendment. You jackass. You were supposed to be a judge applying the Constitution against laws and then seeing whether said laws are constitutional. There was no common use back then. And there are documents that show that all weapons of war were commonly owned by citizens back then. You jackass.
Choose to ask that question.
It comes from page 2143 of the Supreme Court's decision in Bruin, where they specifically
Now,
confronted.
where does it come from? Right? The fact that somebody may say something that you like is not where it comes from. What part of our constitutional history leads to that principle?
It comes from looking at the historical tradition of what types of arms were banned.
Comes from looking at. Does it come from anything concrete in the historical tradition?
Yes, it does. If you look at the 1783 Mass Act, jackass, it shows that people owned every implement of war. I can't get over this, man. These are judges that are supposed to take a law, look at the Constitution, and see whether that law fits within the constitutional restraints on government powers. To be a judge, you are supposed to be a bit of a historian because you're supposed to know what laws are constitutional and what laws have been shot down because they weren't constitutional. Again, I'm a welder. I'm a welding instructor, and I can figure this out. These are judges, supposed to be educated people, informed people, and they're the dumbest sons of bitches on this goddamn planet.
Yes, the laws that existed historically. We look at the laws, that's what Bruin instructs us to do, is look at the types of laws that existed historically and ask what types of laws, looking at those laws, what types of arms were permissible to ban. And there are very few restrictions. I mean, the state points to many regulations, but there are very few laws in this country's history that prohibited particular types of arms. And when you look at those laws and look at them and try and extrapolate from them, what is the basis that ties together the types of things that were prohibited? They were not arms that were in common use at the time. They were instead arms that were highly unusual in society at large and predominantly used for unlawful purposes. That is the historical tradition that's drawn from looking at historical laws, which is what courts are supposed to do in the wake of Bruin.
So do you think the only thing that's excluded are unlawful purposes? Because right now I'm struggling with what I understand to be your concession that the M16, for example, is...
Okay, I can use anything for an unlawful purpose. Criminals do it all the time. Your average cigarette lighter sold at a store. Arsonists use them to light fires to burn people's shit to the ground. Your gangbangers use cars all the time in drive-bys. Anything can be used for an illegal purpose. Governing a product because someone uses it for an illegal purpose is a very shitty way to make law. Yeah, MC, 100%. Although I can't explain thermodynamics, I can explain how materials expand under heat and distort. I can understand a lot of that shit. A lot of metallurgy. I'm actually pretty damn decent at it. But these fuckers, man. Again, yeah. Let's get back to this before I blow a gasket.
Is not one of the arms that's covered by the Second Amendment for the individual right to keep and bear, and that more broadly speaking, our standing army, which is some 1.4 million people these days, and probably would have horrified James Madison and any number of other people who didn't want a standing army, but we have one now, that there are certainly some weapons that in this country, Congress can, the Department of Defense can, whoever we want the actor to be, can reserve to the professional military and maybe by extension to police departments.
No. Heifer. Just saying that means you don't understand what the Second Amendment was about. The Second Amendment was about the government not having a monopoly on force or violence. It's exactly what it was about. So that the people could have these things too. And yes, if fucking Elon Musk wanted a fully functional goddamn aircraft carrier with his own planes, with his own fucking missiles, I don't care. I don't.
But to keep out of the hands of ordinary citizens. Then there's some other set of weapons. So I guess you're saying unlawful purposes, but I think there's another point here, which is that some weapons, while not unlawful per se, perfectly lawful for a member of the Army to have his service weapon, but they are not for Second Amendment purposes the kinds of things that individuals can have.
Fit that thought into your rational brain. Oh, the military can have these, but your average citizens under the Second Amendment, they can't have those, even though the Second Amendment was about a check on government power. And I promise you, and I have seen them, I know them, people who have been in combat, who have put rounds down range in anger, who are horrible with fucking firearms. They don't know anything about them except to put the pointy end down range and pull the fucking trigger.
So I think the question is whether they're highly unusual in society at large. And when the court said society at large.
Warsaw, what up, brother? Hold on for a sec, Warsaw. Let me... give me a sec, Warsaw. I'm going to send you a link as soon as I can freaking get my happy ass straight here. Because this is it. These are the Illinois arguments, like we were talking about the other day. All right, Warsaw, I just sent you a link, brother. Hey, man, post away. Yeah, you got a wrench. So Warsaw's got links to donations to help fight this case. So post away, Warsaw. But I did send you a link too. So if you're not working and you can jump in.
Large, I take them
Sister Ting, what's up? How my nephews doing?
to mean ordinary law-abiding citizens, not members of the military or the police force.
So let me ask you about this 24.4 million number then. I looked, and it was very hard for me to see how it broke down. How many of those weapons are actually owned by law enforcement agencies? How many of those weapons are in the hands of criminal gangs? How many of those weapons are in the hands of people like Dr. Herrera, who has, nothing that appears to suggest why he shouldn't have it, but how does that number break down?
I can't tell you precisely how that number breaks down. I will say, and that's partly because we don't believe that it is our burden to prove that something is not in common use or not typically used for lawful purposes today. I do think it's important to be clear about how we think methodologically all of this works in light of Bruin.
Oh, I agree with that, but I guess I'm reminded of the old, lies, damn lies, and statistics idea, in that we can look at that number, 24.4, let's maybe subtract some, call it 20 million, since maybe some of them are these special uses. But then you look at other numbers and you say, oh my gosh, it's only 1% of, by the time you work through, and that makes it seem not common, and there's no objective principle that tells us which way to think about commonality.
Sure. I mean, I'd say a couple of things in response to that. First, anytime anyone on the Supreme Court has talked about it, they've talked about it in terms of numbers, just simple numbers of possession. So
But
I
they've
think
never faced this issue. They've always,
haven't?
it's been conceded that there was common use. So when the court tells us all the time, you know, if they weren't thinking of an issue, we really need to be careful about how much we read into what they say.
Well, I do want to be clear that, you know, it wasn't irrelevant in Heller or Bruin. I mean, the question in Heller was whether a particular type of firearm may be possessed, a handgun. And the argument was made, you don't need to possess handguns because you can possess long guns.
So
So the court-
everybody agreed a handgun was in common use. Everybody agreed, it was conceded, it says this in Bruin, that handguns are in common use. So how you derive the definition of common use from something that everybody agreed and therefore was untested in the adversary system is hard.
Sure, and here's part of why I think it really needs to be a focus on numbers of ownership. Because if you use basically any of the other metrics that the state has offered in its briefing, you're probably going to end up having to say that revolvers aren't covered, that non-semi-automatic rifles aren't covered. I mean, their statistic for saying that rifles aren't covered is actually a statistic that these rifles that they've banned aren't covered is a statistic about all rifles. And I certainly don't think the Supreme Court would accept the proposition that the right metric for commonality is one that excludes rifles and a revolver, which is what Mr. Heller actually wanted to possess in Heller itself. And so you have to have a metric that is consistent with something that would protect the kinds of things that we think of as in ordinary use by lawful citizens for self-defense, meaning things that people keep in their home, that they practice with to be ready for self-defense. And of course, there's variation among those numbers. But what we are talking about here, these types of rifles that the state has banned, they're the second most popular type of firearm on the market after semi-automatic pistols. They're 3 times more common than revolver sales. They're twice as common as shotgun sales, twice as common as
But that gets back
non-semi-automatic.
to Judge Easterbrook's point about the Tommy guns and the like. I think just because, so your feeling is whatever it is that's popular, maybe grenades are going to be popular soon. That means that people have the right to keep and bear grenades?
Yes, yes.
You know,
they do.
grenades seem to strike me as something that is more arguably not a bearable arm in the sense of a firearm
No, a
that
grenade is an easily bearable arm.
Pick it
That's
up.
the whole point.
Yeah, I mean,
Right? One of the problems that I at least have with your presentation is that it makes the constitutionality of a law depend on where it was enacted, when it was enacted, relative to sales.
No, it is dependent on what was understood at the time, what the language meant at the time. That is what it depends on. It is a legal contract. If I sign a legal contract, I agree to what the words mean at the time that I signed the contract. I agree to the terms of that contract. Someone can't just go along later and all of a sudden just change the meaning of words, changing the meaning of the contract, and then expect me to just go fuck myself while they change what I agreed to. That's not the way this works. This is legal. The Constitution, the Bill of Rights are all legal language. That's why the term shall not be infringed is the strongest legal language that they could have used at the time. If you write a contract now and you say something shall not be infringed, that means the other party has no right, no power to disturb that right.
If there had been a statute in the 1950s when the AR-15 is invented, it would have been sustained on your analysis because by then they are not in common use. But if the state legislature waits 20 years, then the statute can't be sustained.
Well, this case, guys, of course, like I said, we're going to get shot down in the 7th. No pun intended on the shot down part. We're going to get shot down in the 7th. I got almost no doubt about that. But you look at this case is a launching board for all of these bans to go nationwide. If it survives in the courts like this, then you can depend on them going after all of the ARs AKs nationally. So this, and if it makes it to the Supreme Court and the Supreme Court actually rules based on the constitutionality of this and stomps this out, well, then guess what? The next step is the 34 NFA to get stomped out.
All of that is totally extrinsic to either the language of the Constitution or the history of the Constitution. And I wonder how, if we have a historical test in Bruin, how that totally anachronistic approach can be the one required by the Constitution.
So I would say two things. First, I don't think it is necessarily the case that simply because AR-15s weren't common at the moment they came out, they could be prohibited. There is a dangerous and unusual test, and while we feel very strongly that it's a conjunctive test, you need both things. That matters both. You have to be unusual, but also
But then you have to answer my machine gun question the other way, because I'm quite sure
Barrett
the
is
same
looking at this
reason
hard.
AR-15s are owned by many law-abiding people. Tommy guns would be owned by many law-abiding people.
Yes, Tommy guns would be owned by many law-abiding people. I would own one now, full auto. Honestly, what would it matter if my guns back there, that AR-10, that AK, if they were full auto, what would it matter? As long as I didn't hurt anybody, as long as I didn't wrongfully deprive someone else of life, liberty, or property with those guns, doesn't matter. People talk about, well, police will be outgunned. Yeah, in some cases they might. Go get better shit. The state was never supposed to have a monopoly on violence. That's what puts them in check. That's what slows them down and says, hey, maybe we need a hell of a lot more evidence to go serve this goddamn search warrant, because there's some shit that lives in that house that's probably going to be pretty goddamn painful if we run into it. What's up, Night Custom Bills? My brother. What's up, dog?
Today. And therefore, the 1938 statute has to be unconstitutional.
It's a 1934 statute, you jackass.
But you're not willing to say that.
I mean, it's just not consistent with the historical record. And they were not common. So
No, look, my proposition is counterfactual.
Sure.
It's the same as what happens if the AR-15 is banned in 1957. It's not common. But in litigation 20 years later, you would be saying law-abiding people would commonly own it, and therefore it has to be legal. And I'm now saying the very same thing about the Thompson submachine gun. Actually, it's a submachine gun. Maybe it wasn't a real full machine gun, but
Kid's toy.
you see the problem, I hope.
I
You're just fixed on saying the machine gun can be banned, but something that is yay far from a machine gun can't be banned because a lot of them got into common hands before the ban.
So to be clear, if I understood your hypothetical, I'm sorry if I misunderstood you. If, laws changed such
knew it
that
fell
machine
that way.
guns, automatic technology did become the common choice of the American people
No,
for self-defense.
you're just
Smoke
not
so much.
listening to my question. I'm asking, Congress banned the machine gun in 1938. What I want to know is,
No, Judge. Congress did not ban the machine gun in 1938. They restricted them and taxed them in 1934. It wasn't a ban. It was a tax. Again, even though that tax at the time was very much a prohibited tax, the gangsters could still afford them and they still fucking bought them. God damn, these judges are fucking morons. I make no excuse for my language.
whether that is unconstitutional on the ground that today law-abiding people would own machine guns for proper use. The same proper use you
Warsaw
described the AR-15 is having.
And I think if a showing could be made that the American people, given the choice, would choose those, then I agree with you that the answer might be different today than it was back in the 1930s. And
So
the Supreme
here's
Court-
my issue. This maybe is, I'm not sure if this is what Judge Easterbrook is saying or not, but at least my
Why can't this lawyer stop this judge and be like, look, judge, okay, look, machine guns weren't banned. In 1934, the NFA passed through Congress. The National Firearms Act defined firearms, defined machine guns. And what it did is it put a tax on these arms, suppressors. They just got thrown in there for shits and giggles. But it didn't ban them. It taxed them. The congressional record, if you read the hearing, the Attorney General of the United States and Senator or Congress people, all of them agreed they could not ban the manufacture of machine guns. That was an unconstitutional act. That's why they used the Interstate Commerce Clause, a bastardization of it, to put a tax on these guns. And they were actually going after handguns more than machine guns at the time. Fucking, it's like, just fuck me running, man. This is a step below watching goddamn SpongeBob SquarePants to me. I just want to fucking slam my head into the goddamn table.
Usually when we are asked to assess the constitutionality of a statute, whether it's under the First Amendment or, you know, any part, your favorite part of the Constitution, these are enduring decisions. They're not decisions that change based on the empirical basis of what has been happening lately. You know, it's okay to say.
That's why there were no tests written into the Second Amendment. It was arms, period. It wasn't, hey, these have to be bearable arms. It wasn't, hey, these have to be in common use. It wasn't, hey, if criminals use them for blah, 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 then we need to ban them. They already did the balancing test and the arguments before they wrote the Second Amendment. That's why the Second Amendment went through a couple of changes before it was put into the actual Constitution or the Bill of Rights. They already balanced out all of those interests. And what they said is the government shall not have the power to ban arms, period. At the time, if someone wanted to take a wagon, a horse-drawn wagon, throw cannons all over that bitch and roll it down fucking Main Street, they could have done it. Yeah, Warsaw, man, we'll try to put one together. You know, Dark will go live tonight on his own, but hell, I don't know. Maybe late Friday night we'll do one. Say fuck it, man. Let's see whether we can put one together.
Say that child pornography is not within the speech protected by the First Amendment. It's not about how popular child pornography is.
You want to know why child pornography is not within protected speech, you fucking hag, is because it actually harms children to produce child fucking pornography. Oh, the shit I could say.
It's an understanding of what the speech clause means and what its limitations are. And the same thing is true of the other parts of the Constitution. Indeed, there are people who've argued very strongly that the death penalty must be consistent with the Constitution because it's mentioned a couple of times in the Constitution, even if mores have changed. And a lot of people now think the death penalty is immoral. The way to fix that, people say, is at the ballot box. You can get rid of it. But your interpretation means that constitutionality kind of winks on and off depending on how popular a weapon is at any given time. And it's an unusual.
That's the horse shit we run into with these tests that they throw into this shit. There were no tests in the Second Amendment. There were no tests at that time for bearable arms. The minute they started making up all these dumbass tests is the minute we run into this stupid shit where they think they can ban something. Fucking
position to take.
I appreciate that, but I do want to be clear that Bruin actually specifically confronted this question. And it confronted the possibility.
No, it didn't. I mean, let me join Judge Wood in saying Bruin confronted the question that was confronted in Bruin, which had nothing to do with arms like the AR-15.
Choke on it, you mother.
That's why both Justice Kavanaugh and Justice Alito filed separate opinions saying Bruin decides only what it decides, what it's presented. There wasn't any question in Bruin about what is a protectable arm. It hasn't been decided. Now, maybe we should decide.
Bruin said the Second Amendment, the right to keep and bear arms, if it was actually implicated, then you go back to the text and the history and tradition at the time of the founding. You fucking moron! I wasn't planning on doing this way. Well, it's just one of those days.
Decided along similar grounds, but you can't
Feeling like a
retreat
freight
and say
train.
this has all been decided by Bruin. We've got a hard question, and we don't think we can duck it by attributing it to a decision that didn't face the issue.
I was not trying to suggest that Bruin decided the question before this court. I simply was, it addressed the question you
Though
were
your
asking.
brief says that.
It addresses the question you were asking me, which is a question about whether it matters if something was common now that wasn't common back then. And there is a passage in Bruin when the court specifically says, we accept the proposition that perhaps handguns were considered dangerous and unusual back in colonial days. And the court says, even if that were the case, that would not provide a justification for bans on carrying them today because they are unquestionably in common use today. That's at page
Kingpin.
43 of Bruin.
I've read Bruin
So-
too. I mean,
Yeah.
believe me, I've been like putting it under my pillow, but it's,
You can stick
Yeah, I
it
just
up
want
your
to,
ass for all
I
I care,
appreciate
Judge.
that it is a little bit unusual. It is a little bit unusual to have a protection that comes on and off, but
it's
it's
more
also,
than a little bit unusual. It's very troublesome to have, a popularity contest determine a constitutional.
That's because there was no popularity contest in the Second Amendment in the first fucking place. It said arms. In other words, all arms. Guns, cannons, bombs, grenades, mortars, fucking rockets, goddamn fucking nuclear powered submarines. Yes, arms. Fuck me. Why is this so fucking hard? ADX, what's happening, brother man?
Principle. And so that's why I've been looking throughout these arguments for, what is the principle? Is the principle one that allows legislatures to distinguish between military uses and
No.
personal uses? Is the principle one that
The principle was simple. The principle was the people should be armed as well as the government, so the government did not have a monopoly on force. That was the principle behind the Second Amendment. Self-defense didn't have shit to do with it. Hunting didn't have shit to do with it. Those were pretty much a given. You have the right to self-defense. You have the right to fucking feed your family because there wasn't a goddamn Walmart at the time. Jumping. Gee, Hosa fucking fat. ADX, what's happening, man?
privileges the right to self-defense is the principle one.
I'm going to go like
if
Alex
it's
Jones here in a minute,
bearable,
just start
and
like
I assure
tearing
that
shirts.
You and I could carry a grenade around. It's not that hard.
And I do want to be clear about kind of the methodology, which is it's a different question whether something is an arm that's presumptively protected, and then when you get to historical tradition. We think that the threshold question of whether something's presumptively protected is not that complicated and doesn't need to get into an elaborate historical analysis. The Supreme Court said the definition, they used the word definition of the term arms, is bearable arms.
But
things
I'm
that
telling you,
facilitate-
you can say that, but then when you try to put some meat on the bones, it's hard because a bearable arm.
Not hard.
certainly would include the M16, but
I agree.
the court at the same time said they're outside the scope of the Second
But I
Amendment.
don't think the court was saying they aren't arms. It was saying they are arms that may be banned consistent with our historical tradition of banning arms that are dangerous and unusual. So they passed the threshold test. That's just a question of whether the Second Amendment is even implicated.
is
They failed, the
fucking
court concluded,
maddening.
at the second test because those kinds of bans are consistent with historical tradition. And it seems to me quite
And if the
extraordinary.
M16 is dangerous and unusual, it's
Yeah,
certainly not
baby.
any
If I'm
more
hungry, if I'm
unusual than
starving,
the
yeah, that deer's
Oh,
fair
it's
game, baby. It's
absolutely.
going.
Society at large, there's 24 million AR-15s. There's like
But
a
that's,
few
that's,
hundred
that's
thousand.
circular. That's just because the Pentagon says you can't have them. You know,
No!
it doesn't.
That's
Really,
the problem.
The Pentagon has nothing to do with it, you. God, this is a judge. They went through fucking law school to be this stupid. This is a reminder, kids. If you don't know who Hank Johnson is from Georgia, realize he is a lawyer. And yes, he's that fucking stupid. The Pentagon has jack shit to do with it. Yeah, you're right, dude. If Alex Jones was starving, he's going to eat your ass, and probably the rest of you too. I'm just saying that motherfucker.
Circularity is, and the whole
Yeah,
fact
Kingpin,
that this is
100%.
ripped out of
Yeah.
time.
Those
The
two went to law
M16
school
can't be
too.
banned because the Pentagon won't let civilians have it.
Let that sink in. This is a judge. You can't have an M16 because the Pentagon won't let you have it. They've got no say-so in it.
But that just says that what can be banned depends on what has been banned. And as a matter of normal constitutional analysis, that just doesn't work.
So I think that the reason we look at things differently in this context is in part because, I mean, this is an amendment that's passed to keep the government from taking things away from people. And so when the government's trying to take arms away from people that they
Well,
already
then
possess.
you brought the wrong case because Illinois doesn't take any arms away from people.
I mean,
It bans
Illinois-
sales of new AR-15s.
Illinois is saying that there are arms that you no longer can have, and we are.
No,
It's not
there
saying
are
that
arms
at
you can
all.
no longer buy. Right?
You
We
can
can at
file
least
your
state the
registration.
You
statute
can no longer
correctly.
acquire them. You can no longer acquire.
This judge talking about we can at least state the statute properly is a fucking idiot. It is an absolute ban. If it tells you you cannot have it, you can no longer have it, that is a ban. The fuck's so hard to understand about that? This dude, again, is supposed to be a judge. He is supposed to be studied up on this. He is judging this case.
Them, and even people who can keep them can only keep and utilize them under much narrower circumstances than are
only if
traditionally.
they fill out this registration form, which is honestly, no worse than anything else that people fill out every day.
Oh, but there's still significant restrictions on what they can do with them. They can't utilize them like any other arms.
Oh, those restrictions didn't look all that huge to me. You can.
Oh, those restrictions didn't look all that bad. Get on this fucking train. What the Again, these are judges, kids. This is why I say that we have to watch out for the fact that Joe Biden and his administration have put hundreds of judges onto the district and circuit courts, and none of them are friendly to our Second Amendment.
Use them for self-defense. You can take them to a shooting range. You can have them in your car when you're traveling to and fro. There are all kinds of things you can do.
I mean,
with
in
it.
all events, I mean, we have plaintiffs here who would like to acquire these, and they cannot acquire them. And we are
Acquire
talking
is a different
about, things that an amendment that's there.
But that's
How do you bear an arm without first acquiring it?
true of the M16 as well.
Of
You
course it's
can't
true.
acquire it,
Of course, it's true.
even
but,
if it would be really, really useful for self-defense.
sure, but I don't think the fact that there's some arm out there that is unprotected by the Second Amendment is justification
No,
enough to
look,
say.
I hope you see why we're having trouble. If you assume that the M16 is unprotected by the Second Amendment, then of course it's not problematic to ban the M16. But why are you assuming it's unprotected by the Second Amendment? Only because the military has so far kept them mostly out of civilian hands. And if the military...
Warsaw, who you want as a mod? Because, hell, most of the guys in the chat are mods. Matter of fact, I can make more people. I told you, man, I'll make everybody in the chat a mod, and you guys can fight it out like a fucking death match. But yeah, anybody can repost the links. But man, and I've got to get a few things straightened out. You know, hell, I just joined the God damn it, chat's fucking moving on me. Who the fuck did I just join? I just joined another gun group. Hell, I can't even remember which one it is. But definitely need to try to support these cats because it costs millions of dollars to fight lawsuits like this. I mean, literally millions of dollars. And hell, the government, it's not hurting them. They just use your tax dollars to do it. They don't care. They will print more money to take away your rights. And you deal with judges like this that are so fucking mind-boggling, goddamn stupid.
The military had failed or had waited a decade, then they would be protected by the Second Amendment. And that, as a matter of normal constitutional analysis, would be, let's just say, very unusual.
I mean, with respect, I disagree that the only reason they can't be protected is because the Pentagon has banned them. If you look at the history here,
the Pentagon
semi-automatic
can't ban
shit. Automatic technology on this.
The Pentagon is not a legislative body. They can't ban a goddamn thing. Does this judge not understand the simple fucking structure of government?
Civilian market, it had been around for roughly 30 years before
on the civilian market.
Sure, but that's the point, is when
the automatic technology was in use in the Civil War.
I mean, fully automatic firearms came around the end of the 1800s, but they weren't available to civilians. And the Second Amendment is
yes,
about
they
protecting
were,
the rights
bitch.
of what civilians
but
can possess.
Whether they are available to civilians is the very question under review. I don't think you're understanding our problem. That your argument seems to be that if the government is successful in preventing weapons from coming into civilian hands, that is a self-fulfilling prophecy. That therefore they aren't covered by the Second Amendment. But if the government waits before deciding whether weapons can come into civilian hands, then it becomes disabled from ever making that decision. That, as a matter of normal constitutional analysis, is pretty weird.
That just is not our argument. It is not our argument that the reason M16s may be able to be banned is because they were banned. It's because when they came on the market, people did not choose, law-abiding citizens did not choose in significant numbers to purchase. They did come on the private market. They came on the private market.
They were on the private market before they went through military trials and became a military rifle. You fucking numbnuts. Google. For the love of fucking God.
In 1925, and over the course of the following 10 years, instead of a bunch of law-abiding civilians going and buying them, 25 states and the federal government banned them. People reacted by saying these are not the kinds of...
And this is the lawyer arguing for the plaintiffs. Again, this is like two fucking idiots arguing about the color of a goddamn paisley shirt. I don't even really understand what paisley is. But still, this is why these fucking things weren't written into the Second Amendment in the first place. It's very simple to understand for your average fucking moron like me. Oh, shit. I hit the fucking button again. Where were we at?
How many of those weapons are in the hands of people like Dr. Herrera, who has, no
As in ordinary use by lawful citizens.
15 is banned in 1957. It's not common. But in litigation 20 years later, you would be saying law-abiding people would commonly own it, and therefore it has to be legal. And I'm now saying the very same thing about the Thompson submachine gun. Actually, it's a submachine gun. Maybe it wasn't a real full machine gun, but
He doesn't even understand what a submachine gun is. Maybe it wasn't a full machine gun. No, it was fucking fully automatic, you dickhead. It just used a pistol caliber fucking cartridge. Just want fucking fuck.
you see the problem, I hope.
I
You're just fixed on saying
Did I
the machine
rewind
gun
that
can
far?
be banned, but something that is
when you get to historical tradition. We think that the threshold question of whether something's presumptively protected technology that had been on the market for 30 years
Here,
is
maybe we're
radically
back to
different
where
from
we were
anything
at.
we're talking about today. People were happy to continue arming themselves with semi-automatic pistols, with essentially semi-automatic revolvers and rifles and shotguns and all of those things. They didn't clamor to go get this technology. There was instead a groundswell across the country of people saying this is not what we want for self-defense. So
At the time, I could have that gun mailed to my house, to my doorstep, with no background check, no real records of it, cash on delivery, and it was mine. All mine.
I don't think you can say that this is just 100%, the Pentagon said you can't have them and that's the end of it. There was actual history surrounding it, and it was that law-abiding citizens had the option and said, no, thank you. And I think that goes to show that this isn't, it's not as if anything out there that's legal will necessarily be something millions and millions of Americans go and purchase. Americans make choices about what to purchase. It just so happens that what the state has decided to try to ban here is the single most popular thing that people are purchasing these days for self-defense. And I don't think that when you're doing that, first, the idea that a law prohibiting the second most popular type of arm in this country would not even implicate the Second Amendment, would have it doesn't even need to be analyzed under history and tradition. I think the Supreme Court would find that proposition absolutely.
Okay, first of all, this never should have left the state, because the state of Illinois doesn't give the government the power to manage the arms that they own inside of that state. There's nothing in the Illinois Constitution that says the government gets to manage these arms. Nothing. Zero. Zilch. Nada. Not even there. Not the mouse print. There's no fucking, we can rub it down with goddamn lemon and we can bring out the hidden text. None of that shit.
Radical.
Well,
but I think
can I also say, I just want to put some perspective here. There's absolutely nothing in the Illinois law or any of the other laws that are before us that would prevent a future legislature in Illinois to allow the purchase of these weapons. And other states have more liberal policies about what. So in other words,
So what she's saying is the legislature of Illinois can give you your rights and take them away at any given moment, just depending on the fucking or the amount of people in the legislature who are for your rights. Again, this is a judge. This is a fucking district court judge. Hallelujah.
there's a democratic process, there's a legislative process at issue here, and what we're exploring is what are the constraints on that process, and has Illinois gone too far, or have the various, the county and the two municipalities, have they gone too far? But nobody is preventing anybody from using the legislative process.
Sure, but they could say that about pretty much any.
So the legislative process, fuck me, Rena, hit the goddamn button again.
as in ordinary use by lawful citizens for self-defense.
Functionality of a statute, whether it's under the first.
So what she's saying is the legislature, fuck the Constitution. If we're in this democratic process, if you get a majority, you get to strip the minority of their rights and their property. I'm pretty fucking sure that's not how this is supposed to work.
First Amendment, or any part, your favorite part of the Constitution. These are enduring decisions. They're not decisions that change based
I
on
don't
the
care where we're at. We're
empirical
going to listen to it.
basis of what has been happening lately. It's okay to say that child pornography is not within speech
Shit. No,
protected
we
by
got
the
to
First.
speed up.
Well,
Of
you
course it's
can't
true.
acquire it,
Of course it's true.
even
but
if it would be really, really useful for self-defense.
Sure, but I don't think the fact that there's some arm out there that is unprotected by the Second
Speed
Amendment,
it up a little bit.
historical tradition, and the state just has not shown, even in their own
It
words.
depends. I mean, history is so malleable, and
No, it's
I mean,
not.
the state would, I
History's
imagine, they're
not
going to stand up
malleable.
and say, yes, we did, and which historical analogs are the best ones, which are even legitimate ones, is very much under debate among the parties in this case.
It certainly is, but what the state has been careful to continuously say in its briefs, and I heard them say it again here today, is that they've demonstrated a history of, quote, regulation. Okay, I will grant that there's a history of regulation of all sorts of types of firearms. That is not the same thing as a history of prohibiting particular types of arms on the theory that they are too dangerous for the American people.
Except that, I mean, we don't need to belabor this because we've covered it, but there are arms that are kept out of civilian hands, and those are banned.
Sure, but
For civilians.
the justification, if you look at the very few and far between laws that banned particular types of arms, I mean, most of the ones they come forward from the 1800s are the exact same laws that Bruin or Heller or both considered and said these are outliers that are not part of our historical tradition.
Why do you describe it as few and far between? I mean, take the grenade. Grenade is a very portable, very effective arm. It's banned. I assume that you think that ban is lawful. Stinger missiles, bazookas, it's very, very, very easy to rattle off lots of banned arms. So why do you describe them as few and far between?
I suppose I should employ the caveat of arms that are commonly owned by law-abiding lawful
Yeah, but
citizens.
we're then back to this circularity.
Sure.
Grenades aren't commonly owned by law-abiding citizens, in part because they're completely illegal.
But once the state is banning things that are commonly owned, I think they need to show a
Right,
tradition.
and that's the anachronism built into the argument, that if the state waits 20 years before banning something, it can't. But if it bans them right at the beginning, it can. And that's, well, we've been through this.
Yes. Appreciate the frustration. It's
Okay.
unfortunately the anachronism built
Thank
into
you,
it.
Ms. Murphy.
Thank you.
Mr. Mag.
May it please the court, counsel, Thomas Magg for the Langley plaintiffs. Perhaps I want to start out by saying we're not here talking about Stinger missiles, bazookas, or the like. Frankly, I'm aware of no law outlawing them. National Firearms Act might tax and register.
There is, in fact, a specific federal statute about grenades.
National Firearms Act, it's a
Also
tax
includes
statute.
body armor and a bunch of other things.
A bazooka, they're on the market, they're taxed and registered, as are pre-1986 machine guns, of which there are about 200,000 in civilian hands right now. But we're not here talking about rocket launchers and grenade launchers. In fact, machine guns at the federal level weren't banned until 1986. They were taxed and registered starting in 1934 by the federal government, but remained on the market. The reason that there's only 200,000 machine guns in civilian hands is they're expensive, and they were regulated, not banned. What protects the AR-15 and similar firearms, aside from the fact that they are the single most popular firearms in the United States, is that they are also the lineal descendants of the arms, the Charleville musket, the Brown Bess, used at the time of the adoption of the Second Amendment.
So I find, you make that argument, I find it less helpful because it just puts too much in the same pot, basically. There are quite important differences between the AR-15 that you could buy if you went out and bought it today, and the weapon
Nah, I'm
that was used
serious.
at the time of the Revolutionary War. I mean, it's just,
I'd get a
it
snack.
weakens your argument to try to say they're the same thing.
I didn't say they're the same thing. I said the lineal descendants, such as the difference
And
between
so
the
if-
Gutenberg press.
But if they
and-
aren't the same thing, then why? Yes, okay, the Gutenberg press is different from my iPad. I get that. But
Yes, your rights do not depend on how the technology changes. You still have the right to free speech on supposedly on platforms like this. You still have the right to, protect yourself against illegal searches and seizures. Supposed to be. It doesn't happen much. And when firearms change, you still have the right to keep and bear arms. It's that fucking simple.
why is it helpful to say that it's the lineal descendant? It's different. It's unbelievably dangerous.
No, it's
It
not.
is not unbelievably dangerous any more than the bayonet on the end of the British muskets.
I don't, that zooms up to such a high degree of generality. Can they both kill? Sure. Are they both designed for killing? Sure. But they don't kill in the same way, in the same
That's
number
one of the patches
seconds,
that come
in the
out in
same
PLA sent
manner.
me.
But the progression of technology from the adoption of the Second Amendment has been a progression of improvements in range, in power, speed of firing. The argument that the state is making about AR-15s and the like could be applied to bolt-action rifles in the First World War. They have an immense rate of fire compared to the Charleville musket. But I don't think even this court would blink at saying that they're protected by the Second Amendment.
So can I ask, is
that a CRS patch?
Fundamentally, your position is that
Yeah,
with the
PLA
addition
sent
of
it
the
to me. I
Second
didn't realize
Amendment
there was a
to the
CRS patch.
Constitution in 1791, and then its later incorporation in 1868. The legislative authorities of this country at any level were across the board simply disabled from banning or regulating guns, firearms.
Banning rifles, pistols, shotguns of the type typically used at the adoption of the Second Amendment, yes. Regulating, it depends on how far the regulation goes.
So if you can somehow trace a lineal descendant from something that was around in 1791 to a modern weapon, no matter how many improvements, as you say, in accuracy, range, etc., there's just no power in Congress, no power in a state legislature or a city council.
Yes, there is no power. There is no constitution in the United States that gives a government the power to regulate arms. Not California, not New York, none of them have the power to regulate arms. Ryder, what's up, brother man?
To ban that weapon.
I agree that the government does not have the power to ban the great-grandchildren of the brown bess musket.
And doesn't that equally
very
apply to Stinger missiles?
Interesting.
Yes,
The
it
missile
does.
is not a descendant of a rifle, pistol, shotgun used at the time of
It
the
was a
revolution.
descendant of an arm. I mean, there's no phrase in the Constitution about rifle, pistol, or shotgun.
No, I
Ah,
mean,
It's
true.
a descendant of the kind of missile invented in China in about the 8th century.
the Congreve
Been around
rocket,
for a long
instance.
time.
The Congreve rocket used by the British at the time of the Revolution, I don't know if that would be protected.
And
or not.
therefore, in your view, is the Stinger missile protected by the Second Amendment?
Yes.
Probably not, because it would be dangerous and unusual
Sorry, no.
Unusual compared to what?
compared to anything. Even in the military, they don't
I mean,
issue
Duke
man
makes good arguments.
man-portable air
Don't get me
defense
wrong.
systems like the Stinger
I just
missile
simply
to the
disagree
average
with you.
infantryman.
Oh, the average infantryman.
The judge.
I mean, it's like nuclear weapons. Nuclear weapons, even in a military context, are rare and unusual. There might be thousands of them across the nation, but they're certainly not issued and used, at least not used since World War II. And I would note that Centano made clear 200,000, at least in the concurrence in Centano by Justice Alito, that 200,000 stun guns existed per the record in that case in the United States at that time. If 200,000 is sufficient for in common use, we're well beyond that. I mean, we're talking about tens of millions. So I would also like to point out that the issue is not just used for self-defense. It's used traditionally for lawful purposes, including self-defense. Other lawful purpose target competition.
Again, this is where we get into some of these tests that were never written into the Second Amendment that just flat out piss me off. Once we get into arguing about these terms, well, is it used for, common whatevers, and is it used for, lawful purposes? Well, then that means if someone's using it for unlawful purposes, well, then we have the right to fucking ban it. No, government, you don't. You never had the right. It's just like the court upholding slavery. Just because you upheld slavery for decades doesn't mean that slavery was fucking right. Just because you upheld a lot of these restrictions for decades doesn't make them right. It makes you wrong for a really long time.
Hunting to the extent necessary, and the like are also traditionally lawful purposes. And in closing, while I still have a little time, I would like to, we're not here just talking about AR-15s and big bad assault weapons. You take a little .22 pistol, pocket pistol with a threaded barrel, kind of like the James Bond carried in the original Dr. No book.
See what Brady's saying.
That is banned under this act. Pocket pistols with threaded barrels. These are not dangerous, unusual new firearms. They are long existing firearms, lineal descendants of what existed at the time of the Revolution. They are protected.
Thank you, Mr. Mag.
Thank you, Your Honors.
Mr. Dickey.
Yeah, Mag had some good arguments. He really did. And this next guy has some good arguments.
Good morning, Your Honors, and may it please the Court. Gilbert Dickey on behalf of Appellant Dr. Herrera. Dr. Herrera's challenge is principally about whether he can keep his common rifle and handgun magazines in his home. Bruin's text and history framework confirms that he can. We agree with Ms. Murphy's arguments about common use, but would like to highlight 3 features unique to Dr. Herrera's challenge. First, the history speaks with clarity to Dr. Herrera's challenge to blanket bans in the home. Under the Militia Acts, citizens were expected to keep common weapons that could be used for lawful civilian purposes and common defense in the home.
See, with that argument, in some ways it's an interesting argument. It relates back to the Militia Clause, actually, but what I am having trouble with, again, is my sorting question, because people could certainly keep an M16 in their home, too, and it would be useful if the militia were called up and if they were training.
Yes, just like the original challenge to the 1934 NFA, where they said a short-barreled shotgun was not useful in military service, which is horseshit, so it wasn't protected. That means that things that are useful in military service would be protected by that original 1934 decision. And that was the first time that the government actually went in and started taxing and fucking registering guns.
Periodically, in appropriate ways, they would be ready to go, for the militia. So I just don't know why that helps us make the decision that we're trying to make today.
Yes, Judge Wood. So when you look at the Militia Acts, as you say, civilians were expected to...
This dude's got a little bit of a fucking
certain
list.
Types of weapons, and they could lose them.
I want to hear this guy say suffer and succotash so bad I can't stand it.
Their weapons, too, if they poached or if they, in some fashion, misused them.
Yes, and in our case, we point to evidence about the kinds of weapons that those were. Those were the weapons that were in common use for lawful civilian purposes that would also be useful for common defense. And here we actually have record evidence in some of the declarations in our case the M16 and fully automatic functionality, which is the distinction between the M16
Right.
and AR-15, is not useful for lawful civilian purposes. It would be useful for
Why
military
not?
purposes, but Heller makes clear that alone is not enough.
It just strikes me as ipsy dixit. You know, we say it's not useful for the M16 for civilian purposes, but if somebody was frightened and they thought an intruder was coming to their home, rather than have to sit there and aim at the intruder, maybe if you could just spray, weaponry across the.
Oh God, man, these people are so fucking ignorant of how guns work and about how a self-defense situation would go down. If someone breaks in, you just spray them down. Fucking ignorant.
Area, you'd be even more assured of protecting your home.
I certainly understand the challenge you're facing, Judge Wood, and I think...
And of course, that's related to the bump stock question, where bump stocks are used to make essentially fully automatic application, which is now, I assume.
No, bump stocks didn't make anything fully automatic. They just made it available where you could bump fire a gun and fire it faster, a little easier, because a lot of people can bump fire about any gun out there. Look at Reno May. Reno May's got plenty of videos where he's bump firing shit. Mac, Military Arms Channel, bump firing shit. It just made it easier for another person to bump fire. It's like fucking training wheels for bump firing. That's all it was, you fucking idiot. It didn't make anything full auto. Full auto has a textual definition in the goddamn law that says how full autos operate. Fucking
Assume about to be reviewed by the Supreme Court.
Gonna blow gas.
Right? If a bump stock is protected by the Second Amendment, why not an M16?
Yeah, BV.
Or any other machine gun?
Your Honor, our argument is not...
I know your argument is not about bump stocks, but we live in a world where the Fifth Circuit has just held that bump stocks cannot be outlawed.
Yes.
And where the Solicitor General has asked the Supreme Court to review that. Anything we say today will be read against that background too. So I'm asking whether, in your view, bump stocks and the M16 are protected by the Second Amendment, precisely because they can be used to spray bullets.
By their logic, you need to go find Jerry Michalik and cut his fucking fingers off. Because then it's about rate of fire. How fast can you fire something? And Michalik, if you have an AK with a rate reducer in it, he can fire faster than that AK. With his finger. Bah, 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 bah. Yeah, you need to find him, figure out what lab he was fucking grown in, and destroy the lab and cut his fucking fingers off. And by the way, just go ahead and get his daughter, go ahead and throw her in prison, because she's a fucking machine gun all by herself. Fucking. How many times can I say fucking on one stream?
So our view distinguishes between semi-automatic rifles
break
like
a
the
record.
AR-15 that Dr. Herrera would like to keep in his home and fully automatic functionality. And that is exactly because fully automatic functionality is designed to, as you mentioned, spray fire, which is useful in the militia setting.
And it's useful for somebody who is, say, 75
Listen
years
to this argument.
Not very familiar with firearms, confronted by an intruder at home, and would be much more likely to be able to protect himself from the intruder if he could just pull the trigger once and move the gun around.
Your Honor, I don't think that's the record in our case.
I'm not asking about the record in our case. I'm asking about a feature of an automatic weapon. Right?
Oh,
that's how automatic weapons work. It's why the military likes them. It's why a 65-year-old...
No, the military likes fully automatic weapons for what you call suppressive fire. That way you can put more hate down range than someone is throwing at you, and you can make them put their heads down while other people can maneuver, and usually in semi-automatic, put them down. Suppressive fire. You jackass, you're talking like you've got this place of authority and you know what you're talking about, and you're proving to be a fucking idiot. Maybe this is why I'm not a lawyer, because there's no way I could stand there and get hit with that amount of fucking stupidity without asking a judge, are you a fucking moron or did you smoke some goddamn crack?
Or 80-year-old arthritic homeowner may think it would be terribly important to be able to defend himself that way. I understand you don't want to answer this question. That's exactly why we do want you to answer that question.
Right. What I'm trying to point out is we do not believe that that's the kind of lawful civilian use that would be expected under the Militia Acts, exactly because, as we've shown, we think it's useful for suppressive fire, but not for self-defense,
Yes.
whereas the semi-automatic
But
functionality
why? Look,
is-
I just told you how it's useful for self-defense. Somebody who is not a gun expert.
Yeah, that way some jackass can go spray bullets all through their house, hit their fucking neighbors, kill their own family because they're just fucking spraying and praying. That's an absolute fucking stupid way to use a gun for self-fucking defense. I wish to God one of these judges would see one of my fucking streams and watch it all the way through and then beat their own goddamn head flat with the fucking skillet from their kitchen because they're goddamn stupid.
Who might have arthritis, is trying to defend himself.
Fucking
The ability to pull the trigger
bust a
once and
blood
move the gun
vessel.
around is very effective for self-defense, one might think. Right?
certainly one might think.
Yeah, one of the quotes is, Brooke, you're right. And it comes down to, oh God, you said it and now I can't remember. But it basically came down to, if you're an idiot, or people think you're an idiot, it's better for them to think it than for you to open your mouth and fucking prove it. And this dude is opening his mouth and he's proving it over and over and over and over again. Brooke, I don't know how you stay as calm as you do. I don't know.
That I think the distinction we're trying to draw is, I hate to keep going back to the record, but I think what our expert declaration shows is it's not a useful tool for actually hitting your target and effectively defending yourself. And semi-automatic.
Not a useful tool for hitting your target. If I recall the data, if you think about the military use of the M16, what is one bullet in more than...
It wasn't just the M16, and I think it was less than 1 in 100 rounds actually struck a target, because that's what you call suppressive fire, Judge. When you get into an ambush situation or you get into a situation where someone is shooting at you, you put more lead in the air than they put in the air, and you make them put their heads down so that everybody else can maneuver and then destroy those enemies. It's a very common tactic in the military. I've never been in the military. I've been around plenty of people in the military. I've had people explain L-shaped ambushes to me, which are fucking cool, unless you're the one trapped in that L-shaped ambush. But good God, man. I just... You want to walk up to this judge and be like the fucking cartoons where you blow into your thumb and your hand gets fucking real big, like Mickey Mouse with having his hand blown up, and just slap the dog shit out of him. Yeah, Brooke. Yeah, do that topic. I will be in the chat. You have to explain that one to me, because they don't make enough Xanax for me to stay calm.
100 hits its target, but the military thinks they're useful.
Right.
So you think the military is just wrong in thinking that these kinds of weapons are useful?
We've put in evidence from people highly experienced in military operations that the use for it in the military setting is predominantly for suppressive fire. And
that's the kind of question I was asking. You're a homeowner, you're worried about the intruder, you just want to make sure that he gets hit somehow without your having to aim the rifle at him.
Right. I think that's different from what I'm saying. Suppressive fire is
I
not.
know it's different from what you're saying, but why is it a constitutional rule, right?
It's like he just fucking he takes stupid and he's throwing it out in buckets whenever someone tries to speak common sense to him. They're like, no, Judge, here's common sense. And he throws a bucket of fucking stupid over their head. And they go, no, Judge, here's common sense. And he fucking picks up another bucket of stupid and throws it over their head. Just, yeah, BB, yeah, it's for keeping tyrants in check. That's what it's for. Fucking with that meme with Danny DeVito. Yeah, I just came out blasting. Yeah, oh, damn it, man.
Why is it that the Constitution allows a state to prohibit that kind of use by a law-abiding person?
The Constitution doesn't allow the prohibition on that. It doesn't. It doesn't allow prohibitions on any of it. The Constitution and actual just laws, excuse me, beer, burp, the Constitution and just laws prohibit you from putting someone else in undue danger or unduly depriving someone else of life, liberty, or property. That's what the Constitution and just laws do. And if you're a jackass living in an apartment where bullets can go through walls and someone breaks into your home and you spray and pray and you kill your neighbors, you're responsible for every fucking bullet that comes out of that gun. Every single one of them. And if you kill your attacker, but you kill your fucking neighbor, guess what? You're responsible for your neighbor's death. You just murdered your neighbor. They might plead that down to manslaughter because you really didn't mean to kill your neighbor, but you did. But guess what? You stopped your attacker. Everything's great. Your jackass gets to go to fucking jail anyway.
Person to defend his house and does not allow the state to prohibit a similar use by a very similar weapon. Trying to see how the Constitution draws that line has been very difficult,
Right.
for me at least.
I
you're a
understand.
fucking
I think
moron. That's
Artest
fine.
drawing from the Militia Acts draws two distinctions. The guns, and we think at a minimum,
It could
you
be
cannot show a
made,
history and tradition
BB, yes,
of
could.
banning weapons in the home.
That's
that were
what
useful
would be
both for
handled in
lawful
court.
civilian purposes and in common defense. We think the AR-15 is the prototypical weapon that would fit in that. And I think here, I just want to turn briefly, if I can, to, I think it's important to understand who the militia was referring to when in these militia acts. Presser, which we've cited in our brief, makes very clear that the militia refers to all able-bodied citizens capable of rendering aid.
Now listen to this other judge kick in
It
here.
makes very clear.
Able-bodied white non-native citizens.
I don't believe that's what Presser says. Certainly some of the militia acts said that.
In
And there were-
1791, you think they were arming people of other races or
In some cases, they were, bitch. Yes, they were.
folks here? I
We
think so.
don't dispute that there would be other constitutional problems with the militia acts. We point to Presser, which we think is consistent with what McDonald and Heller say about the militia, where it clearly defines it.
So here's the deal, kiddos, perps. There were laws, there were regulations at the time that were restricted to race in the United States. There were. There's no doubt. But the thing about a constitutional right is when it is expanded to cover more people, that is constitutional because you're growing, you're expanding it to cover more people. When slavery went down, when people figured out, hey, we don't have to have this shit, we can get rid of it, and these people that we have that were other races, black and others, and we can expand the freedoms to them, that is constitutional. You can't take a constitutional right and shrink it and then call that constitutional. It doesn't fucking work that way. It's just, I need like a, I don't know, stress ball. I need to chew on the barrel of a shotgun, something. Anyway,
as able-bodied citizens and not some state-regulated entity. And in fact, if you look to the militia clauses, it's very hard to imagine it being a state-regulated entity because it's actually the United States government that is responsible for organizing the militia, and it's the only one
be like Biden's red speech.
Forth the militia. The state's authority is to appoint the
Maybe go
officers
green.
and
I like the blue.
see to training according to the instructions of the United
blue.
States. So we're not talking about some
Blue.
state-regulated entity. The militia was
Let's
a
go blue.
pre-existing body of people before the Constitution, composed of all able-bodied citizens. And so we think these acts show that that weapons that were useful for lawful civilian purposes, like the AR-15, and that's
Yeah, Kingpin, you're right. Slavery has been fought over since day one. The formation of the United States was the first actual civil rights movement. But I mean, before the Constitution was signed, when you had all these people come to America and say, we need to be free of these governing forces that are taking away our human rights, that was the original civil rights movement. And our founders were smart enough to know they had enough on the line where some things were going to take a little while, but they wrote into our Constitution the way to abolish slavery. And they knew it was on its last legs then. Our founders knew that. And that was part of the reason they wrote documents the way that they did, so it could be abolished. Because fucking people don't understand, slavery was the norm at the time. These people grew up with slavery as the fucking everyday thing. It had nothing to do with race. It had everything to do with power. We have a monopoly on force, so we can take those people and make them do what we want them to do. We can make them do the shit jobs that we don't want to do. And before people talk about Native Americans and everything else, Native Americans owned slaves long past the time when slavery was so-called abolished in the United States, because they had their own nations and they were separate from the United States. People, the history we get taught a lot of times is absolute horse shit. And if people understood this fucking shit, maybe we wouldn't be in the position we're in now. But you have a large majority of society in America who wants to stay ignorant. They will fight their ass off to stay ignorant. And they will listen to the government and they will think everything's about race and we need to be looking at other people for race and this slavery shit and all right. That's a whole nother rant. Yeah, Kingpin, close public schools. Get rid of the Department of Education. Fucking burn that shit to the goddamn ground. Fucking I'm gonna do a clicker one time of a stream like this on how many times I can say fucking, fucked, and everything else. Like, you know, you check how many people are coming in the door to club.
not just limited to self-defense, clearly, but also target shooting and the like, were protected by the Second Amendment. And if you look to Heller, where it discusses, there's been some discussion of sort of like the M16 test. What Heller is actually saying is the mere fact that something might be useful for the militia is not enough. It's actually explaining why, despite the usefulness for militia purposes, so the militia purpose was cutting the other way there, but it was explaining why when a weapon is highly unusual like the M16, that's not enough just because it would be helpful for militia purposes. Just briefly, I want to talk about the district court's irreparable harm finding. EZEL confirms that Dr. Herrera is suffering irreparable harm. He is currently prohibited from keeping his AR-15 in his home and training with it. Those are the exact harms that were at issue in EZEL. So we think that was clearly wrong, was a legal error. If there's nothing further, we would ask that the court reverse.
Thank you, Mr. Dickey. Ms. Hunger, anything further?
Yes, Your Honor, just a few very brief points. Going back to Your Honor's questions about first principles, our view is that our standard, both at the plain text and the historical tradition step, or whatever we would like to call it, post-Bruin, is consistent with these first principles, because on the one hand,
Barnaby, what's up, brother?
whether or not an arm is useful.
DB
for
Cooper
self-defense,
slipped in. What's
or on the
happening?
other, whether it is typically used or best used or most suitable for the military or criminal uses. And I think that is consistent both in the plain text and also looking at the historical tradition.
How does the plain text answer that?
Yeah, DB, you're right.
Well, in terms of what an arm means, our view is that
There's nothing in the plain text that tells you what an arm means.
That's correct.
So let's stop with this plain text stuff.
Okay, my apologies, Your Honor.
Okay, jackass. At the time, arms had a specific definition, which were basically any implement of war. Again, our states at the time agreed to specific words and definitions that made up the Constitution. Arms at the time had a definition. That is the definition of arms we agreed to. You fucking slap nuts. Sorry, Brooke.
In terms of first principles, looking at categorization of self-defense on the one hand and military and criminal use on the other hand, under kind of a history and tradition, and as Bruin indicated, would govern here. I also would like to note on a different topic, plaintiffs discussed a lot, these firearms are available, they have also been available, but another piece of the story is the marketing techniques. And here, as is clear in the record,
I was having a lot of trouble with your adversaries about constitutional history, but I must say, I don't see how marketing techniques have anything to do with the Second Amendment.
Is another problem.
I don't think it's conceivable.
Yes. We agree. Yes.
See, this judge, and I still don't think he'll rule in our favor, because I think he's got a bone up his ass. But he catches on to a lot of this as far as like the marketing stuff, and he gets into it in a minute, I think, about like rates of fire and stuff with lever actions and the winning of the West and shit. But I don't think he's going to be able to swallow his fucking pride and actually write a decision that is constitutionally based. Yeah, cluster bombs. No, I can't use those. We'll ship them to Ukraine. Man, them motherfuckers need them.
Yes, I was just.
Thank you.
Right. Thank you. Okay. And finally, in terms of a few places in the record where you can look to see why the weapons of the 1950s are different from the semi-automatic weapons, I would look to Exhibit B of the Andrew Declaration, which is kind of a contemporaneous report, the Yergolitis Declaration, and the Hargarten Declaration.
So are we looking at this to shed some light on dangerous and unusual, or are we looking at this for some other reason?
Oh, that would be in response to this notion that the semi-automatic weapons of the 1950s are the same as the semi-automatic weapons of kind of the late 19th century and the early 20th century. In our view, is that those are not the same, and that is merely our record support.
I must say, I don't understand that either. Do you think
someone get these judges to subscribe to fucking Forgotten Weapons and let Ian educate them on what fucking technology was out there? The AK-47, bitches, it was started in what, the 30s or so, and then was adopted in 47. Maxim machine guns, 1919s. All of those were legal for civilian purchase. The fucking Maul Deuce, the M250, was available for civilian purchase. Fucking, again, just fucking buckets of stupid just poured over everybody's head.
The famous Winchester repeating rifle is protected by the Second Amendment?
In terms of the text or the tradition, or just the overall?
I'm asking about the bottom line. The text doesn't tell us what an arm is, right? And I want you to think about the Winchester repeating rifle, right? Not any kind of muzzle-loading rifle as of 1791, right? But the rifle that made the West, the one where you could crank the pump and shoot again much more quickly than anything before.
Jackass.
And it would have a magazine of some number of rounds. It was not. It was, in a sense, like its predecessors, but in a sense, it was the AR-15 of the day. Was it protected by the Second Amendment? Is it protected by the Second Amendment today?
He does kind of have that right.
Our view is that certain restrictions may have been lawful, for example, on the concealed carry of those weapons, which I believe were in existence in the 19th century, which may be different than a complete ban on those weapons, which may not be protected for that purpose.
That sounds pretty fuzzy. Is that your final answer?
I like how these people just fucking giggle while they're trampling over our rights.
The Supreme Court has said that the restrictions on concealed carry of revolvers and rifles of those type are constitutional, and so it does depend on I think what the restriction is. So that is my final answer. Yes.
Yeah, Kingpin, they need to watch the History Channel.
I suppose finally, and just noting kind of this page 2143 that my opponents spent a good amount of time on, which I've also read quite extensively.
Yeah, Tales of the Gun was a good
view
show.
Of that paragraph is, yes, the Supreme Court did use the word common use. It was in distinguishing, I believe, one or two regulations in its entire kind of historical analysis. It was not establishing the test. And if your honors have no further questions, we ask that this court affirm in Beavis and Herrera and reverse in Barnett. Thank you.
Thank you, Ms. Hunger. Ms. Scheller, anything further?
Thank you, Your Honor. Nothing further on behalf of the county defendants unless the court has specific questions for us.
I see none, so thank you.
Thank you.
And thanks to all advocates.
Dang old Matt, what's up,
An
brother?
extremely difficult problem, and we will take the case under advice.
Yeah, Matt, 100%.
The court is in recess.
Okay, so that's the arguments out of Illinois. The same day this happened, this set of arguments, I think it's the Fifth Circuit was going through oral arguments on the pistol braces. So I'll tell you what, you guys tell me, because I've not blown a complete gasket yet. And I can't remember who all's on. I think Polite Society comes on at 8. But anyway, if you guys want to continue listening to some oral arguments, I'll pull up the Fifth Circuit oral argument and we can run through those. But if you guys want to do that, what I'll do is I will start a separate stream and we'll start with the Fifth Circuit oral arguments on the pistol braces. So you guys tell me yes or no in the chat. If you guys want to listen to some more, we'll listen to some more. You guys can watch me like, I don't know, blood coming out of my eyes. But yeah, let me know. And I might start it up anyway. But yeah, the same day this happened, the pistol brace arguments were happening. And those are interesting too. Because the judges in the Fifth Circuit react to the arguments a bit different. And some of the lawyers for the plaintiffs with the pistol braces are a lot more on point with our rights. So I'll tell you what, I'm going to stop this one here, and I'm going to crank up another stream. It'll take me a minute or two, but I'm going to crank up another stream and start in with the oral arguments for the pistol braces out of the Fifth Circuit. So yeah, I'm going to stop this one here. So all of you guys be cool. Matt, brother, damn, I still got to send your stuff out. And I'm, like I said, I'm going to pack some extra stuff in there. And pretty much every day that goes by, I'm going to throw more shit in there. So you might end up with a fuckload of a bigger package. Yeah, brother. Warsaw, we'll get with Dark and see when he wants to do it, and we'll run it. Dark's a cool dude. So fuck, man. Anytime I can get on the stream with him, get on the stream with you, and we can do shit like this, I'm all about it. So yeah, we'll run it, man. Anytime you and Dark want to do it, I will make time. The only time I have a restriction on what I'm doing is this Saturday at, I think, 8 o'clock, 9 o'clock. I'm going to do the Polite Society podcast again with Paul, and I can't remember who else is on the panel, but I will be on there again. So you guys check into the Polite Society podcast, the Daily Bullet, because I will be on there again. Last time I was on there with Tony Simon. I can't remember his name. He's a firearms trainer, but a bunch of cool dudes. So yeah, this Saturday, the 15th, I'll be on there with him. And that'll be another fucking great show. Paul puts on a damn good show. So yeah, I'm going to end this one here, man. I'm going to crank another one up here in just a couple minutes. I might snag something real quick. So it'll be a couple minutes. It'll take me time to get Rumble back up and all that. Because I'm dual streaming to Rumble and fucking trying to cover some bases. But anyway, you perps be cool. Keep that thing on you at all times. And I'm out.